That is yours.
Yes.
My lord, pertaining to civil bench 2, my lord.
Yeah.
I beg to pray for listing, my lord, on tomorrow, my lord. Very urgent, my lord, because
Tomorrow there may be difficulty.
my lord, otherwise, my lord, she will be handed over the SARS, my lord. The present applicant is, my lord, 6 years senior than
Okay, tomorrow.
tomorrow. Obliged, my lord. May it please your lordship.
Oh.
May it please your lordship.
Yes.
Your lordship, with respect to item number 115, which is listed in the hearing list, your lordship. Item number 115 in the hearing list, your lordship. I'm praying that the matter may be fixed on Tuesday for hearing, your lordship. It is not reaching. The person is in the ICU, your lordship.
Oh.
So I want that the matter may be listed on, taken up on Tuesday, your lordship.
Tuesday, 19.
When the part 2 list, your lordship.
Part 2 list.
Yes, your lordship.
Okay.
I've taken the consent from the other side.
Okay.
Tuesday, your lordship.
May it please, your lordship. Lordship, item number 15 for today's list, my lord.
Yes.
My lord, with the consent of other side, my lord, matter will be taken after 2 weeks, my lord.
Okay, on request made by Mr. N. Boral,
Right.
the council for petitioner list after 2 weeks. Yeah.
May I please, sir?
Yeah.
These two matters are transfer matter, my lord.
Oh,
Tomorrow, my lord.
why
Motion-
tomorrow?
Motion, my lord.
Why? Why?
So because the other person who may take the charge, my lord. The transfer matter, they have been appointed for election duties, but on the other hand, they transfer to other district, my lord. So it is,
So it's on the basis of the election commission's
Yes, ma'am, yes.
direction, isn't the
yes,
transfer?
no. On the basis of election commission direction, they have been posted as a sector officer in their place of posting.
Hmm.
In that way, the government has transferred them. So those contradict, my lord. Those two things have contradicted now.
Let's see.
Tomorrow, my lord, motion, my lord. Yes, sir, we have. Obliged.
Lordship, item number 7 of today's list, Lordship.
Yeah.
I have instructions to withdraw this petition, Lordship. This, if your Lordship will recollect, this is a matter relating to sending to training on promotion. So they have communicated my promotion has been kept withheld. So Lordship, I have instructions to withdraw this case, Lordship, with a liberty that if need arises, I'll approach.
Mr. R.K.D. Chowdhury on the council for petitioner. Request for withdrawal of this writ petition with liberty to file afresh if required in the near future.
Yes.
So, who
Okay.
appears government? Which police department, isn't that?
No, it's state.
Home,
it's,
home,
Yes, Lordship.
state, who's appearing? Non-appears, okay. Writ petition is accordingly dismissed on withdrawal with liberty as paid for.
Lordship.
May I beg your lordship? My lord, the matter pertains to bench 2, my lord. A very urgent matter, my lord, for admission, my lord.
Oh,
On Monday, my lord. Bench 2, my lord. Yes, it's 20.
yes.
On Monday, my lord. Obliged, my lord.
May I please, your lordship? I beg to mention for withdrawal, my lord. Tomorrow, my lord. It is for just withdrawal.
Monday.
Obliged.
May I please? Item number 13.
13,
Yes, Lordship.
yes.
The matter will be taken on 28, Lordship. Senior counsel PGS has some difficulty today. We have taken consent from the government.
On request on behalf of PG Saika, petitioner's counsel.
Lordship.
On request made on behalf of Mr. PG Saika, then counsel. List after?
On
1 week.
28, if possible, on 28, Lordship. 28/3, if possible.
28 will not be possible.
First week of April.
4th April.
4th April. Obliged.
Lordship, prayer for listing one WPC 512/2016. It is an old pending matter, Lordship. The matter may come upon for hearing on 3rd of April, Lordship.
Hearing,
Yes, Lordship.
4th April.
4th April. Obliged.
May I please, your lordship? Lordship, motion has been taken from the other side. I beg to mention item number 18, lordship.
Yes.
Due to some personal difficulties, Mr. P. Sharma arguing counsel do not appear today.
Who's the arguing counsel?
Mr. P. Sharma.
P. Sharma, petitioner.
Yes, lordship.
Okay, on request made on behalf of
Let's better
Mr. P. Sharma,
3 weeks.
counsel for petitioner list after 3 weeks.
Obliged.
May I please, your lordship? I beg to mention for listing. So matter may come up admission on 18th of March.
No,
Already a matter was fixed on February. So till now,
21st.
obliged, sir.
My please, your lordship. Lordship, I beg to mention WPC number 1183
Hmm.
of 2024 for listing on next week.
Next week, no?
And WPC
27th.
There's two items, WPC 872 of 2022.
Both on 27th.
My lord, these two matters for listing, my lord, may come up on admission, my lord. On Monday, my lord.
Not Monday. First April.
My lord, on 8/9, the notice was issued, my lord, on 20.
So let it come on 8 April. First April.
And another listing, my lord, is better pertains to bench two, my lord.
Oh,
This notice was issued, my lord, on 5/2, my lord.
oh.
However, this matter is not listed yet.
So it will come to April, first week April.
I'm praying for listing and admission matter, lord. Maybe it may be taken in 22, lord, or 27.
27.
27.
May please your lordship, with your permission, may I beg to mention read petition number 2161/23. May please your lordship, I beg to mention this case for listing of for admission.
April, first week,
April 1st week.
yes.
Oblige your lordship.
My lord, I beg to mention for listing WPC number 4193 of the 23. It was last listed on 28/7/23.
Okay,
So next
first
week,
week
my-
April,
Next week, my lord.
first week April.
Okay.
I beg to mention item number 13 of court number 16.
Huh?
Item number 13 of court number 16.
Court number 16, that case, the cost list is deferred.
Actually, we want to list the case.
Yeah, it's already deferred. All the cases are deferred, so it will be notified later on. Okay, does.
Item 1 of daily list, motion.
Please, your lordship.
Yes.
Lordship, matter pertain to a family pension of an unmarried dependent daughter of a government servant. Lordship, last occasion, I have taken time to file an additional affidavit. Kindly see the additional affidavit, lordship, page 58.
Page,
58, lordship.
yes,
Lordship, here, lordship, non-marriage and non-employment certificate issued by the block development officer. That is in 64 page, lordship. May I read, lordship? Certificate to be submitted by pensioner, certificate of non-employment. I declare,
it's not the non-marriage certificate.
yes, lordship, below
Okay.
certificate of non-marriage.
Okay,
I hereby declare that I am not married. I have not been married during the past 1 year.
Hmm.
Signature Rina Boda, name of the pensioner, let's Surendranath Boda, his father. PPO non-lordship, it is issued by the block development officer.
Hmm.
In my humble submission to allow her pension, family pension, from the date of execution of the notification. lordship.
Notice is issued,
No, Lord.
The covered case, lordship.
maybe the covered case, but then the respondents will have to take some instructions, isn't it? Yes, Bhattacharjee,
Yes, lordship. We want to obtain instruction.
so we issue notice.
Yes, Lord.
But Mr.
M. Bora.
Then the council for the petition, issue notice. Stop. You are appearing for
I'm for one.
Mr. J. Handy, Learned Standing Council, Revenue appears for response number 1. Pension,
I'm for 2, 3, 6, and 7, lordship.
okay, MSM Bhattacharjee, and additional senior government advocate appears for 2, 3,
6 and 7.
6, and 7. AG, AG. Finance, AG, we can record A.R. Talukdar's name.
Yes, lordship, I can look that.
Mr. A.R. Talukdar, isn't it?
R-
R.K. Taru. We heard Mr. R.K. Talukdar, Standing Council, Accounting General, appears for response number 4. And MS RM Barwa, then standing council. Okay, and Mr. Kalyan, then it's standing council finance appears for respond number 5. Notice and respondents all of the contract. Extra copies, list after 4 weeks.
I will express.
To admission.
In this matter, notice was issued.
Yeah.
Private respondent, Lordship, 4, 5, 6, 8, 9, 10 has entered appearance, Lordship. And respondent number 2 and 3 has filed affidavit, and respondent number 8 and has filed affidavit, Lordship.
Respondent 2 and 3 has
2 and
filed.
3 filed affidavit, respondent 8 has filed. And respondent number 8 has filed affidavit. On the last occasion, one of the respondents took time to file affidavit, Lordship.
Respondent 8 has filed.
Lordship.
And the other respondents?
They took time to file affidavit, Lordship, on the last occasion.
Last occasion, A Kalita.
Lordship, for filing for respondent number 1, I will not file any affidavit. I adopt the affidavit filed with APs because we don't have any role, Lordship. They have explained everything, I adopt affidavit.
Now I am for respondent number 4 minutes. Now I have to file a affidavit. I need some time to file a affidavit.
One time.
Yes, ma'am.
Lordship may fix a date, Lordship. By that time, the respondents may file the affidavit and I may be allowed to file the reply also, Lordship.
Third, Mr.
D does, Lordship.
D Das, you are the counsel for the petitioner. Stop. Mr. A Kalita, standing counsel. Industries and Commerce.
Right.
Appearing for respond number 1 submits that he is not filing affidavit and will be relying on the affidavit filed by the Assam Public Service Commission. Stop. The respondents 2 and 3 has filed contract. 2 and 3 and the respondent number 8
8.
has filed a respective contract. Stop. How about 7, 9, 10, all these are represented or not?
Lordship, 7 and
You have 5 and 1 minute. You have 5 and 10. And the others?
Now I am for 4 minutes.
You are 6 and 9. And 7.
7 and 11, Lordship, they after receipt of notice, they have not entered appearance, Lordship. Service is complete on them.
You are appearing for?
Respondent number 4 minutes.
Respondent number 4. Mr.
S. Botakumar.
S. Botago, Leonard's counsel for the respond number 4, comma. 5 and
10.
Mr.
10.
P.K. Boyan, Leonard counsel, appearing for respondents 5 and 10. And then MS. S. A. Ahmed, Leonard counsel for the respondents 6 and 9. In 8, you filed your affidavit. Jointly placed for, how much time you require? 3 weeks. 3 weeks will suffice, all of you? Placed for 3 weeks time to file the respective contract. There is a lot. List after 3 weeks.
Lordship may be free, please to fix a date, Lordship.
Fix a date.
Lordship.
22nd April.
Lordship.
Must be.
3.
Maybe the words. One petitioner herein had challenged the order of punishment imposed upon him
Okay.
and for non-promotion even after.
Affidavit has come?
My lord,
Affidavit has come?
affidavit has not come, council is not also present. Fortunately.
Affidavit has been filed, isn't it?
No, affidavit they have filed earlier, my lord.
Oh.
But they are stated that during this period, his promotion
Yes.
was considered, it was kept in seal cover.
Goswami?
Lordship.
We wanted to know what was the seal cover and why it was not considered thereafter also.
Respondent number 2.
Yes, Lordship.
Principal Secretary. Procedural. So two has filed.
Yes, Lordship. Two. Affidavit file.
Number two has filed.
Yes.
You are challenging the departmental proceedings.
And thereafter, my lord, I have not been promoted,
Hmm.
even though there is no punishment for stopping my promotion.
What was the punishment? No
For
punishment.
two increments only, my lord, with cumulative effect.
3 increments
That was reduced to 2 in appeal.
in appeal.
In appeal, it was reduced to 2.
Where's the appeal order?
My lord, that will be at
Page 53,
53. Yes, my lord.
correct?
Yes. That reduced to 2 increments.
Hmm.
During that period, I was not considered for promotion, and thereafter also, after a long time, my lord, I have been promoted.
Yes, then what happened?
Now I am, but in that process, my lord, I have become junior to all my juniors, my lord.
Hmm. During the period you were undergoing the penalty of two
increments.
establish of 2 increments.
2 increments. And during that period also, I was not considered for promotion.
Hmm.
And thereafter, I have been promoted. And in the meantime, my lord, during my proceedings, when it was pending, my juniors were promoted. And they said, my lord, it was kept in seal cover, but nothing has been produced here. My lord.
Yes.
They should have opened it.
During the pendency of the departmental proceedings
Hmm.
against the petitioner, and during the period of penalties, his promotion was not considered as decision were kept in the seal cover. That is true.
Hmm.
During the same period, his juniors were promoted because the juniors have no such type of obstructions.
Hmm.
Thus, the offense, the officers who were junior to the petitioner, who got their promotion earlier than the petitioner, and the petitioner lost his seniority, and due to which he did not fall within the zone of the consideration due to that proceeding. On the other hand, the officers who were initially junior to him but gained seniority during the period of DP, the period of penalties, were promoted. This is the fact of this case. Now, for the question of opening the seal cover, Lordship, I will instruct the of concerned party.
So you get instructions.
Yes, Lordship. That I will.
I passed a judgment in this,
Yes,
in
Lord.
a similar matter.
Yes, Lordship.
We have held that the punishment when undergoing punishment, if the juniors supersede the petitioner, there's no infirmity. It's in your favor.
Lordship.
It's something with regard to ABDCL.
APDCL, Lordship.
Find out that judgment.
Yes, I will find out.
Heard Mr. D.B. Chalyal, and the senior counsel, assisted by MS.
Emerald.
M. Royal, and the counsel for the petitioner, Mr. J.K. Goswami, and the governor, additional senior governor. Praise for
Lordship, pays for 2 weeks time.
2 weeks time to enable him to receive instructions. Instructors. 2
Let
weeks.
it be, my lord. It will be listed only after April, after PO,
Lordship.
because I'll be away.
You'll be away.
I will be away.
When are you coming back?
During the holidays, I will come back, my lord. Let it be on 23rd, 24th, any day.
It's the matter on 24th April.
Much like.
For.
My lord, this madam will pass over, my lord, for the timing.
Why?
My lord, Mr. H. Gupta is in court number 12, my lord, is on legs.
Up to some time?
My lord, Lordship may dispose of the matter in very narrow compass, my lord. The SCR which were, my lord, not communicated to the petitioner, that were relied upon by the DPC before it was communicated to the petitioner. Law is settled in this case, my lord. Law now the export is in time and again.
So he wants it passed over for some time.
Another date, my lord.
You want another date? Not today.
No, I don't know.
Or at two, my lord, or at two, because some hearing matter is going on.
Some other day, madam, next week.
Okay, on request made by cycle and comes road. We'll go to April. 8 April.
Just before BU vacation, madam, there is, that will be declared as motion day, madam.
Motion day.
Can it be on 28th, madam?
Of March.
March, madam,
That will be difficult.
28, madam.
Difficult.
On second,
Okay, second.
madam.
Published.
Published, madam.
5.
May it please the lordship. My lord, this matter pertains to a recruitment process where the petitioners were the aspiring candidates belonging to reserve category, my lord. On the last occasion, your lordship has given a direction to the registry to reflect the names of the standing council for state level recruitment commission and the Board of Secondary Education, SEBA, my lord. But my lord, again, I see in the cause list, the name has not been reflected again today, my lord. All right, at the beginning.
Registered doing, I mean.
At the very beginning, my lord, may I just kindly submit, my lord, learned counsel Sri T.C. Sutia was appearing for Board of Secondary Education. There is already an order of this honorable court. My lord, the order which issued notice
SEBA.
for SEBA, my lord, and the state level recruitment commission is also, I believe, my lord, represented by Mr. Sutia, my lord, T.C. Sutia, my lord. If your lordship comes to the order dated, my lord, 22/05/2023. At the my lord, the second my lord, the second last paragraph, if your lordship sees, since the name of the standing council SEBA is not reflected in the cause list, let the copy of the petition be served upon its standing council Sri T. Chutia, whose name is to be reflected in the cause list. So, my lord, there was already an order for reflecting the name of the learned senior council, my lord. So we have some little urgency, my lord, because the process is already over, my lord. Appointments has been made, my lord. We have a case wherein, my lord, by flouting the procedure, they have basically not, they have basically proceeded with the recruitment process, my lord. And our candidature has been rejected because, my lord, we do not score the limited, my lord, the marks that is required, my lord. But they didn't publish the merit list, wherein, my lord, they need to show what was the, my lord, the cutoff mark for a last selected candidate in that particular category that we are representing, my lord. We are reserve category candidates, my lord. And they, without publishing any merit list, without letting us know, in fact, RTIs will also file. And from the RTI, we have come to learn that we have scored more than the, my lord, the cutoff marks, my lord. So the records would reveal everything, my lord, perhaps, if they produce the records, my lord.
Anybody appearing SEBA?
Nobody, my lord.
Can you catch hold of
Mr. Sutia, I can verbally, I can tell him, my lord.
make a request?
My lord,
Take up after some time.
But today, my lord?
Yeah.
I'll just make a confirmation whether yes.
Just see.
I'm highly obliged.
See.
Yeah, please.
On the last occasion, we were asked to bring certain instructions, Lordship. Accordingly, Lordship, I have received just instruction just now. Here, Lordship, like to come to this first page, Lordship. Here, the endorsement has been given for 4,600, Lordship. The GAD had written to the finance department. Concurrence.
Where is that? Where is that?
Second page, Lord. Second page.
Second page.
Yes, sir. On being consulted, the finance department at page 0.5. On being consulted by the finance department, oppose views as below. Finance agrees towards stepping up the pay of the petitioner from stage of 4390 to the stage of 4600. We are given for 4,720, but they have given for 4,600 only. My lord, finance is not a party in this matter, man.
Finance is not a party.
They're not a party, man. And their view will be necessary. Since we have already sent it to the finance department and they've given the view also.
Why don't you make finance a party?
My lord, here the deputy commissioner is the authority for considering all this, my lord.
No.
My lord.
By administrative control, lordship.
My lord.
How
Sir.
can you say that?
And
The concurrence of the finance department is required. Yes, Your Lordship.
Then let me make the financial party money.
Okay. Mr.
User Sakya.
UJ Saikia and the counsel for the petitioner prays for how much time you require
2 weeks time.
to file NIA?
File an
Prays for 2 weeks time to file an appropriate application for implement of the finance department as party respondent in the present litigation. Praise Allah, list after 2 weeks.
all time.
Well, I think 8 minutes, the forest department doesn't have any vacancy, my lord. So it's been taken up with other departments to seek out vacancy. I need another 2 weeks, my lord. There's a letter addressed to the special chief secretary. Look. এখানে আছে আইফোন আছে আপনার রিপ্লাই কোড
Yes.
Just 2 weeks time, my lord. We are trying to take out vacancies for other departments.
Heard, Mr.
J. Kolika.
J. Kalita, Mr. D. Gogoi, Learners Council appearing for the responder number.
My lord, there's only one respondent, one.
For the sole respondent submits that there are no vacancies in the forest department in grade 3 to accommodate the petitioner. And the respondent is exploring for suitable vacancies in other departments for appointing the petitioner on compassionate grounds. Stop.
No, he is compassionate, he is appointed, but there is some change because he was directed to be
For observing the petitioner
in grade 3, my lord.
in grade 3 post. Stop.
And my lord, the
He
person is
therefore
retired.
prays for 2 weeks time.
And in the meantime, my lord, this person else was retired, superannuated, my lord, the PCCF, the sole respondent here in my lord.
But still he is in lordship, he is working lordship as a chief, special chief secretary.
He has got
Under the same department of forest department.
He therefore prays for
2 weeks, man.
2 weeks time. 2 weeks
Fixing a date lordship under the
Wait. Please down 1 minute. Third April.
Third April lordship.
Hold it.
Okay.
9.
May I please, your lordship, my lord, in this contempt petition, my lord, before going to the order, my lord, violated, my lord, I may be allowed to bring on some facts of the case, my lord. Facts of the case is that, my lord, the petitioner in the read petition, my lord, was the president of the Gao Panchayat, my lord, and as per Panchayat Act and the MG and Rega Act, they had prepared a list of development schemes, my lord, under MG and Rega, and Gao Sabha, as per Act and MG and Rega and Panchayat Act, Gao Sabha approved the list, my lord, of 59 schemes, my lord. And as per law, that is required, my lord, and that was forwarded for, my lord, approval, my lord. But, my lord, what happened, my lord? Instead of approval of these schemes, my lord, selected by the Gao Sabha, approved by the Gao Sabha, the block development officer, my lord, along with other officials of the block and the local interface of local MLA, they prepared another list of 53 schemes, my lord, violating the law, my lord, provisions of law, and forwarded it to the deputy commissioner. Deputy commissioner, my lord, approved the schemes, my lord. The schemes include some of the schemes already, my lord, my lord, implemented.
Yes.
Already, there is no required for any schemes. I have annexed the list of those schemes, my lord. This honorable court, my lord, on the first day, my lord, page number 8 is the order of the petition, my lord.
Yes.
My lord, on the prayer of the departmental, on the, my lord, submission of department council, that, my lord, if appropriate representation is submitted, the grievance of the petitioner will be looked into, my lord. Accordingly, my lord, the operative part, my lord, page number, last paragraph of page number 8, my lord, in view of the above, I dispose of the writ petition on withdrawal by granting 7 days time to the petitioner to file appropriate representation before the respondent number 1. If such representation is filed within a week from today, accompanied by a certified copy of this order, the respondent number 1 shall consider the same and take appropriate decision in the matter as expeditiously as possible, preferably within 3 weeks from the date of receipt of the representation. So, my lord, my representation is next page, my lord, page number 10. So this representation, my lord, I have mentioned that all these, my lord, the case of the petitioner, that it was the prayer, my lord, page number 18 of the representation, my lord. That it was the schemes that was illegally approved.
No, I'm not going into all the merits.
Yes, my lord.
I'm going to, this court is considering whether the respondents have complied with directions passed by this
Yes,
court.
my lord,
What
that,
happened after
that
you-
was not, my lord, complied with, my lord, because, my lord, the case of the petitioner was that to cancel the schemes, my lord, which was illegally, my lord, approved by the deputy commissioners, my lord. But the the affidavit, my lord, they have submitted, my lord. The action taken, my lord, of the officials, my lord. Officials have been suspended. Officials have been, my lord, terminated. These are the actions, my lord. But nothing is mentioned about the schemes, my lord. That was illegally approved, my lord. That was the grievance, my lord. How it is complied with, my lord. Nothing is mentioned, my lord.
So you have disposed of the representation.
No order is passed, my lord.
I'll show you.
No order is
I'll
passed, my
show
lord.
my lord. My lord, what has happened on that day when the writ petition was filed? This honorable court did not want to interfere with it, wanted to dismiss the petition. The next day, my lord, they have engaged the senior counsel, he came, my lord, and ultimately, my lord, the matter was withdrawn. However, liberty was granted to file representation, my lord. That was the background of the case. Now, kindly see, my lord, I have filed an affidavit, my lord. What happened? My affidavit filed on 9/10/23, my lord. Please come to my 9/10/23, my lord. My affidavit. Page number 34, my lord. Now, regarding this illegality, because there are certain schemes, he said there are some schemes in his favor, others said there are schemes against them, my lord. So, what has happened, my lord? The principal secretary took up the matter. Page 34, lordship, kindly peruse, my lord. Principal secretary, commissioner, secretary direct the commissioner to make an inquiry. Exactly what has happened? Because there is so much allegation, my lord. Now, please come to page number 36, my lord. Kindly see. These are the inquiry officers, my lord. Page number 36. 1, 2, 3, 4, 5, 6, 7 persons are there, my lord. Inquiry officers. They submitted report, exactly report, my lord. That's in page number 39. Please come, my lord. Page number 39. The following officials, lordship, kindly see. The 1, 2, 3, 4 names are there, just above that. The following officials under Shunai Development Block are found to be involved in the process of implementation of the said schemes. In view of the above, the authority may like to take appropriate action against these officials as per deemed fit and proper. 4 persons. Now, please come to page number 41. 41.
Yes.
After finding these people are involved, these 4 officials, my lord, they have informed the petitioner also that we are going to take actions against them. Now, please come to page number 42, my lord. Next case. There's an order, my lord. Kindly see. Out of 4, 1 officer against him, my lord. Last paragraph, kindly see page 42. Whereas on perusal of records, page 42. Last paragraph. Whereas on perusal of the records, it appears that delinquent officials, Bashir Ahmed, Boroloshkar, such and such, is found to be involved in various irregularities and malpractices, negligence of duty, and such and such. Next paragraph. Now, therefore, considering the outcome of the inquiry report dated such and such, the rules awarded penalty withdrawal of 1 successive increment with such and such. Department proceeding drawn up against Bashir Ahmed, Borwi, such and such. Now working is my lord disposed of. This one, my lord, he has been penalized. Second petition person, my lord, same thing in page number 45. It was done. Page number 45, second person. Now kindly see, he's so powerful, my lord. 2 of the employees have been terminated by the principal secretary because of these allegations, my lord. This much he has taken. Now, these are all honorable single judge wanted to tell him last occasion, want to dismiss. These are all politically. Why don't you go to the government?
But
Why
it
for
was
that?
not on record, my
That
lord.
was the
What is
reason, my
submitted
lord.
by senior
I'm
counsel, my
saying,
lord.
my lord, he was
Regarding
there.
the dismissal
He
part.
was there. He was there.
My lord, what was my prayer, my lord? My prayer was not considered, my lord. Page number 18, my lord. My prayer, nothing is there, my
That's a
lord.
different course of action now.
Exactly.
My lord, what was the, my lord, this honorable court directed, my lord, to dispose
This
of
is not the forum, my lord.
my
It's not
representation,
petition.
my lord.
This is not the forum.
This is not a forum to consider all this.
Exactly.
My lord, my
You have
representation.
met your representation.
Yes.
On the basis of the representation, they conducted an inquiry.
My lord.
2 officials were, departmental proceedings were initiated.
Yes,
They were given penalties.
Yes, my lord.
And three were terminated.
Yes, 2 terminated.
2 terminated.
Another 2 has been, intimate has been directed, my lord.
So four officials have, so what more do you want?
And there is another issue, my lord. Please, another issue, my lord. Let me just finish it, my lord. Please come to page 34. Please, 34. Just have a look, my lord. Interesting something. Please, 34. Please, 34. Now, what is saying about the next schemes? Answer is here. Page 34.
Yes.
Yes, let me read, my lord. This is from the Commissioner Secretary to the Commissioner. With reference to the above, I am directed to state that Petitioner Tahe Boruia, President of Panchayat, in the above retreat has alleged serious anomalies in the preparation and execution of the list of schemes under MGN Rega during 2020-21 pertaining to Sunai Department block. Next, you are requested to conduct a thorough inquiry into the matter and submit report immediately within 10/5/24/21 to the undersigned for further necessary action. Next is important. Meanwhile, you are requested to maintain status quo in the implementation of the schemes under this schemes, my lord. This is what. Now what happened, my lord? The government wanted to act on that. Now, the moment status quo was passed, the opposite party filed a writ petition, and my learned friend appeared for the opposite side, and I was in the Panchayat department. I also represented one of the respondents, my lord, government respondent. He appeared for the private respondent. He knows it very well. Not possible. Case is pending, my lord. Ask him, my lord. Yes or no? Ask
My
him.
lord, that is another matter, my lord. Why my representation is considered, my lord. That is my humble submission, my lord.
What else is
was
required, my
prayer
lord?
in the representation, my
Nothing
lord?
suffices in the context.
Exactly.
My lord, the representation is prayed, my lord. Prayer was that, my lord. The schemes to be, my lord, set aside, my lord. What is illegally approved, my lord. That is my prayer, my lord, page number 18.
Your prayer may be there, but then they've done what they have to do. They've conducted inquiry. Officials have been suspended. Terminated.
But prayer remained unconsidered, my lord. Prayer remained unconsidered, my lord. Prayer was that, my lord, the
You filed a writ petition.
scheme was to be, my lord, implemented, my lord. The illegal scheme was to be set aside, my lord.
That has been
Nothing-
directed to maintain status quo for implementation of the scheme.
That was, my lord, interim, my lord. Not final, any decision is taken, my lord. That was my humble
Until
submission.
further orders.
Yeah.
Until further orders.
Yes, my lord. Yes, my lord. That is
Then
interim.
writ petition is filed.
Please allow me to submit, my lord.
Writ petition is filed, isn't that?
Yes, writ petition, private.
You are appearing for the private response.
Yes, my lord, yes.
Then
But, my lord, this,
no.
this direction is not, my lord, complied with,
cannot
my
keep
lord.
this contempt case pending anymore.
My lord, that
I'm
may,
closing the matter.
that may be liberties given for challenging, my lord, the for cancellation of the, my lord, schemes, my lord, illegally, my lord.
It is only open, my lord.
Illegally adopted, my lord.
That no liberty is required. You can file.
Because, well, as per court's order, I have filed the representation, my lord.
So
As per
on
this
the
honorable
basis
court-
of that representation, you have passed the order.
But the prayer is not considered, my lord. Page number 18, my lord.
Mr. M.G. Kati, Learned Counsel for the petitioner. Also heard Mr. M. Nath, the Senior Counsel, assisted by MS. T.N. Dekal, Learned Counsel for the sole respondents.
Yes,
How many respondents?
Yes, my
Sole respondents.
sole respondents.
By this writ petition, the petition is alleging willful disobedience of the order dated 29/1/2021 passed by this court in WBC number 311/2021. Stop. The relevant portion of the order dated 29/1/2021 reads as under page 8. 8 way. Stop. Para. Pursuant to the order dated 29/1/2021, the petitioner met his representation on, when did you make your
2/2/2021, my lord.
On 2/2/2021. Stop. Thereafter, comma, Where is that order status quo?
Page 34.
Draft. The Commissioner and Secretary PNRD Department by a communication dated 5th May 2021. Addressed to the Commissioner, Panchayat and Rural Development Assam. Directed to conduct an inquiry into the matter and and submit report immediately within 10/5/2021. And also directed to maintain status quo on the implementation of the schemes under integrated natural resource management schemes. Stop. Pursuant to the inquiry conducted. The two officers were penalized by withholding of one successive increment with cumulative effect. And where is that other termination?
My lord, I have given the extra copy to lordships, my lord. That 2 copies.
And by order dated, and by
20th November.
orders, by two orders,
Yes, my
both dated 7/2/2024.
February, yes.
Two officers were terminated from the services. Stop. For Mr. M.G. Katil and the counsel for the petitioner submits that the contempt against the that contempt proceedings against the petitioner should be initiated inasmuch as the directions passed by this court on on 29/1/2021 has not been complied with. However, on consideration of the materials available on record, particularly the affidavit filed by the sole respondent.
Yes.
This court is of the considered opinion that substantial compliance has been made by the sole respondent, and accordingly, no contempt lies. Stop. Accordingly, contempt petition is closed.
Applies.
Obliged.
Then. May it please your lordship,
Yes.
I am appearing on behalf of SP Das. We have received the affidavit filed by the respondent. Lordship kindly grant us 3 weeks time to file the reply.
Okay.
Lordship may fix a date as this matter has been pending since 2018.
2018 or 2023?
Actually, there was earlier petition also. There is.
Where's the earlier petition?
Lordship 4930/2018.
That was disposed of.
That was already disposed of.
Why are you saying it's pending from 2018?
A matter.
Without considering the facts, how are you making your submissions like this?
The matter pertains to same.
Mr.
Lordship A along.
A. Alam Learned Counsel appearing on behalf of Mr. S.P. Das, Learned Counsel with the petitions. Praise for
3 weeks time.
3 weeks time to file.
Lordship may
Reply
fix a
to
date.
the counter filed by the respondents.
Lordship kindly fix a date.
List the matter on 24th April.
Obliged.
5, technician.
May it please your lordship. My lord, my friend is appearing.
My lord, the matter may be fixed on the next week, along with similarly situated case also.
I don't know what is similarly.
My lord, for those similarly situated cases, my lord, already I have made an application in registry. It will come next week. My lord, till then, my learned friend can obtain instructions in this matter, my lord.
Okay.
Yes, ma'am.
Third, Mr.
H. Buragohen, my lord.
H. Buragohen and counsel for the petitioner. Mr.
D.K. Roy.
D.K. Royal and standing counsel Seba. Praise for how much time you require?
I know that next week, ma'am.
Praise for a week's time to receive instructions. Praise the Lord. List the matter again on, when do you want?
But can it be after, post, holy recess, If in
After Holi,
after, can it be, I have some difficulties during holy time,
then first week April,
Yes, first week April will do,
3rd April.
Third April. I'm highly obliged,
In the meantime, no, so the registry is also directed to reflect the name of the standing council Seba and SLRC in the cost list.
I'm highly obliged,
Hearing.
Here, RK Dipsodary is indexed in another court, for the time being,
Okay. That is the lordship, madam.
In this case, also, as part of last of the lordship, we are required to produce the record in connection of the, it's an appeal basically, lordship. And the second, this thing is that lordship, from yesterday onwards, to say, we are not able to raise the, our copy of the disposition lordship, that's why I am not acquainted with the facts of the case today, lordship. Otherwise, the appeal, this record in connection with the appeal has been received this year, lordship. So I need some accommodation for today, lordship. Because I doesn't know the facts of the case as I haven't got the.
Where are your records?
This is the record also.
A short date may be given, man. How much time you require?
4-5 days also. Let me get.
Okay, heard, Mr.
Yes, yes, my name is A. Chaudhary.
H?
A. Chaudhary.
Oh, H Chaudhary. On request made by Mr. C.K. Baron and its government advocate. List the matter again on, when do you want?
Next week, lordship. Next week. Also, it may be recorded that the record has been received in the order.
Okay, cancel the on request made. Mr. C.K. Baron and government submits that he has received the records. However, he prays for a short accommodation in the matter. Please, accordingly, list matter on, when do you want?
Next week, lordship. Any day, Tuesday or Thursday.
Tuesday, madam.
Not 21st.
All right.
14.
2017, that nobody is.
If lordship may kindly pass over, or lordship may fix the matter at 2, my lord, if possible, man.
Why?
My lord, actually, I have some urgent case in court number 1 also, man. Item number 15, that's it.
Okay.
At 2, lordship. Leave, please.
16.
Petitioner counsel.
My senior, Mr. P.K. Tiwari, your lordship, appears for the petitioner. I'm for respond number 4, 5, and 8. The issue here, your lordship, is that the rules stipulate that if there is promotion and recruitment taking place in the same calendar year, the promotees will supersede the direct recruits. My seniors counsel, my seniors clients, the petitioners, they were promoted in the year 2013. My recruitment happened in the year 2012. And I've gained a march in the duration list. That has been put to challenge. That is the gist of the matter. And
Okay, none appears for the petitioner. Mr.
M. Sharma.
M. Sharma, Leonard Counsel, appears for respondents.
4, 5, and 8, your lordship, private respondent.
4, 5, and 8. List after 2 weeks.
I'm grateful, your lordship.
17.
Lordship, in this case, the petitioner was working in the post of LDA.
Lordship, can this matter be taken after some time?
Why?
My senior is on different case.
But
We don't get-
on several other occasions also there's been
He's coming, just he's in different court.
time being
Just
Lordship
for
may
time being.
oblige.
Midfield Lordship. Apologies, Lordship, we have just missed item number 16. We are here, Lordship. Lordship can grant me just 5 minutes. Mr. Tiwari is on the way.
I've already passed orders.
19.
Where were you?
I was engaged in another code, Your Lordship. I just came running when I saw it. I was just watching the board, Lordship. It was showing item number 12. And all of a sudden,
Okay, cancel the order. Yes.
grant me just 5 minutes, you will be here. 5 minutes.
Why should I wait for 5 minutes?
Apologies, Your Lordship. But just for another, Lordship may take up the next matter. Thereafter, we'll be here, Your Lordship.
Yes.
Oblige, Your Lordship, oblige.
19.
In this case, the records were received by the state respondents, my lord. On the last occasion, they have said
You
that
got the records?
Yeah, we have received the records, Lordship, and it's just coming actually from the office.
I can start, my lord.
What is this matter?
He was discharged from service, my lord. So he was working as a constable in the Assam police, my lord. He was discharged from service.
Yeah, proceed.
Yes, my lord. My lord, the first order which was passed, my lord, the discharge order is at page 32, my lord.
Page
32, my lord.
32, yes, please.
I have gone through the inquiry report of the inquiry officer on all records of the DP number so and so drawn up against the delinquent constable number so and so of this unit. While constable number so and so was a battalion headquarters, he was allowed to avail 8 days of casual leave with effect from so and so, but he neither resumed his duty nor sent any intimation to this office about his inability to resume his duty and continued to overstay leave willfully. Accordingly, 3 numbers of notices were issued dated so and so. Out of these 3 notices, notice number 3 was duly served to him on 5/12/15 through OC Kolaigaon PS and as intimated by his letter number so and so asking him to resume his duty immediately. But even after receiving the notice, he failed to resume his duty and continued to overstay leave willfully. Getting no other alternative, he was placed under suspension with effect from 11/12/15 for his unauthorized overstaying leave with effect from 11/9/15 by this office memo number 16/12/15, an order was issued to draw up a departmental proceeding against the delinquent constable. Accordingly, a show cause notice was issued by this office letter dated 28/12/15, which was duly received by him at his home through Havildar so and so of this unit on 3/1/16. He, however, failed to submit the reply of the show cause notice issued to him till date. In this regard, 3 reminder notices were issued to him by this office reminder number so and so. And out of the 3 reminder notices, notice number 3 was duly received by him through special messenger number so and so of this unit on 15/5/16. However, on 7/6/16, the delinquent constable reported his joining at his battalion headquarters after OSL by 269 days. Since even after joining, he did not submit the reply of the show cause notice, the reminder notice was issued to him by this office number so and so, which was duly received by him physically the same day. But instead of submitting the reply of the show cause notice, he remained unauthorized absent from battalion headquarters on 17/7/16 to 27/16, and again from 28/7/16 to 7/8/16, and again with effect from 9/8/16 to till date. It is established from the record of the DP that the delinquent constable number so and so of this unit intentionally indulged in gross misconduct and insubordination for willfully neglecting lawful order. Hence, the DP was ordered to initiate an ex parte. During the course of inquiry, the inquiry officer made several correspondences with the delinquent through OC Kolaigaon PS asking him to appear before the inquiry officer for recording his statement in connection with DP number so and so drawn up against him. But in spite of repeated intimation, he failed to appear before the EO. Moreover, as per WT received from the OC Kolaigaon dated 29/9/16, The delinquent was not willing to appear before the EO as directed, hence the inquiry officer submitted the finding of the DP as ex parte. Against a notice was issued. Again, a notice was issued in 2 Delhi newspapers on 13/1/17 asking him to appear at his battalion headquarters within 7 days of the date of publication of the notice, but he continued to remain absent willfully. Moreover, another show cause was issued to him by this office letter dated 2/2/17 asking him to make representation, if any, against the inquiry report within 7 days from the date of receipt of the notice. The said notice was physically received by him on 5/2/17 at his office, duly signed by him on the date so-and-so of this unit, but even after lapse of 7 days, he neither reported back at his battalion headquarters nor made any representation. It is quite clear that such indisciplined person in the police force is undesirable and will adversely affect the discipline of the force. Under the circumstances, keeping all of the above view, I, being the disciplinary authority with due application of mine, came to the conclusion that so-and-so is discharged from service with immediate effect from 13/2/17. He should not be paid anything else whatever he has been paid earlier. So against this order, my lord, an appeal was filed by the petitioner at page 34 before the DIG. I had stated the grounds in my appeal.
Then what happened?
Then, my lord, along with the appeal, I had filed a delay condonation also. Then after that, my lord, in between, the appeal was filed on on 6/11/19. And in between, during the pendency of the appeal, since they were not taking any decision, I had approached the Honorable High Court. And on 9/10/2020, at page 48, an order was passed to dispose of the appeal within a period of 1 month. At page 48, my lord. Then subsequently, later on, I came to know that on 23/9/2020, an order was passed. The appellate order was passed on 23/9/2020, which was subsequently furnished to me, my lord, at page 50, reiterating the discharge order, my lord. Appeal order, may I read, my lord? Page 50. Peruse the appeal petition preferred by so-and-so, Mandakata, against discharge from the service order bearing memo number so-and-so. The departmental proceedings by DP number so-and-so filed drawn up against so-and-so is made available to examine the instant appeal. On scrutiny of the departmental proceeding records, it is transpired that the constable number so-and-so of Assam Commando Battalion was allowed to avail for 8 days casual leave with effect from 1/9/15 to 11/9/15, but he resumed his duty on 6/6/16 after 269 days OSLN. Though he reported his joining at the Commando Battalion on 6/6/16, but he was found to be unauthorizedly absent on and off on 3 occasions in between the period from 19/7/16 to 9/8/16. Thereafter, he had been absent with effect from 11/8/16. As per records of the SM Commando Battalion, he has been unauthorizedly absent again with effect from 11/8/16, and he has remained absent since then. For his long desertion and unauthorized absence, Dharmendra Borov so-and-so was placed under suspension by the disciplinary authority with effect from 11/12/15, and an order was passed to initiate departmental proceeding against him. The first and second show cause notice were issued on so-and-so and were served on so-and-so at his home address through local police station, that is Kolaigaon PS, and even after publication in 2 local newspapers dated so-and-so. Finally, the disciplinary authority appointed the inquiry officer to conduct the departmental proceeding ex parte. The inquiry officer submitted his findings stating that the charge framed against the delinquent so-and-so of the Commando Battalion, there was gross misconduct and insubordination is proved beyond all reasonable doubts. Accordingly, the disciplinary authority passed his final order by discharging the delinquent number so-and-so of the Commando Battalion with service with effect from 13/2/17. On scrutiny of the departmental proceeding filed, it is transferred that the disciplinary authority has followed all the due procedures in this case while bringing the departmental proceeding to a logical conclusion. I, therefore, being the appeal authority, do not find any merit in the appeal. The appellant, being a member of disciplinary force, deserves no interference in the order passed by the disciplinary authority on 13/2/2017. Further, he preferred his appeal only on 6/11/19 after a long gap of without further indicating any reason for the delay. That as per Rule 66 of the Assam Police Manual, no appeal shall be considered by the appellate authority if it was not preferred within 6 months of the date on which a copy of the order is appealed against was communicated to the appellate, and no reasonable cause is shown for the delay. The instant appeal petition preferred by so and so is time barred and stated above accordingly. Appeal petition is disposed of accordingly. So the appeal was dismissed, and against which I have now preferred the writ petition, my lord. Only on 2 grounds I have challenging the order of the discharge and the appeal order, my lord. First, my lord, is that if my lord may kindly peruse
You have been discharged under which rules?
under the Assam Police Manual.
Under the Assam.
But there is no provision of discharge, my lord. That is my second ground. First, I will go to the first ground, my lord. If my lord may kindly peruse page 22. This is the inquiry report, my lord. This is the this show cause, my lord. The show cause is part of page, starts from page 19. There they show listed witness, 3 numbers of listed witnesses, my lord, at page 22. Dilip Kumar Boro, Narayan Das Commando Battalion, and OC Kolaigaon. These are the 3 listed witnesses, my lord. And my lord, if may kindly peruse page 28. This is the inquiry report. It starts from page 27. Number 3, it's down below, just before the findings, my lord. Page 28. Thus, in keeping, just before the findings, thus, in keeping with the above, the examination of the delinquent and the prosecution witnesses, as well as the cross-examination and recording of the statement, could not be taken by the undersigned, my lord. So the witnesses could not be examined, my lord.
Why? For what reason?
That they are silent, my lord.
Read it from
Para
3.
During the inquiry, self-issued notice number so-and-so to the OC Kolaigaon to intimate the delinquent official so-and-so at his residence to appear before the inquiry officer for recording of statements in connection with the DP number so-and-so. The RI, SM and the RO of the Commando Battalion Mandagata were directed to appear before the undersigned office at the same time, along with the delinquent for recording of statement and cross-examination, if any. Since the delinquent failed to appear on the date fixed for examination and recording of his statement, 2 other subsequent dates were fixed on 15/9/16 and 21/10/16 for the same, but the delinquent failed to appear on those dates too. Moreover, as per the WT received from the OC Kolaigaon, dated so-and-so, the DO was not willing to appear before the EO. It may also be pertinently mentioned that the 3rd reminder notice dated 12/10/16 was physically served, and the same was signed and received by the delinquent so-and-so. So that is the case. So my lord, now, as regards this issue, my lord, there is a judgment of the Apex Court. I think my lord may be aware of the judgment Roop Singh Negi versus PNB, reported in 2009 to SCC page 570. Relevant 9 to SCC 570, my lord, 570. The relevant paragraphs are 14 and 23, my lord. It says, my lord, in paragraph 14, my lord, that the witnesses have to be examined, my lord, to prove the document, my lord. In the present case, my lord, paragraph 14, my lord, the witnesses were not examined. Paragraph 14, my lord.
Yes.
And my second ground, which I have taken in my petition, my lord, is that there is no concept of discharge under the Assam Police Manual, my lord.
Where is the Assam Police Manual?
I have brought it, my lord. Rule 66, my lord.
Rule
66.
is it the same book?
This is VK Diwan, my lord. Mine starts at page 435.
PK was.
Major penalties, my lord.
Or
Rule 66, major penalties, my lord.
this manual. Rule 66.
66. It starts from suspension, major penalties, minor penalties.
One minute, one minute. Yes.
Major penalties, number A is dismissal from service, which shall ordinarily be disqualification for future employment. B is removal from service, which shall not be disqualification for future employment. C is compulsory retirement. D is reduction to a lower service grade or post or to a lower time scale or to a lower stage in time scale. E is recovery from pay of the whole or part of the pecuniary loss. F is black mark and G is withholding of increments and H is censure, my lord. So there is no concept of discharge from service.
Where's the order?
That is the page 32, my lord. Para 30, page 33, second last paragraph. Under the circumstances,
Yes.
I, being the disciplinary authority with due application of mine, came to the conclusion that constable number so and so is discharged from service with immediate effect. So there is no concept of discharge, my lord. And there is a covered judgment, my lord, of this court itself, my lord. WPC number 1136 of 2013, my lord. There's a judgment rendered on 29/9/23. The relevant para, my lord. Para 25, my lord. Para 25 and 31. May I read, my lord? This person was also in the police service, my lord. With regard to the contention that discharge from service is not a prescribed penalty, this court finds force in their argument when the rules governing the field do not prescribe such a penalty, the same cannot be imposed. This court is unable to accept the submission made on behalf of the state that import and meaning is to be gone into and discharge can be construed as dismissal. The different penalties prescribed under Rule 9 of the rules have different connotations and implications, and therefore such submissions are not acceptable.
What is this? What is the court referring to? Rule 9 of which rules?
This is the Assam discipline. Yes, my lord. Even there also there is no concept of discharge. And
how do you know that you have been discharged under the Assam manual?
Because the show cause shows the Assam police manual, my lord. At page 19, my lord, may kindly peruse.
Page 19.
First show cause notice, my lord.
Yeah.
You are hereby directed to show cause under section 65 of the Assam Police Act 2007, read with Rule 66 of the APM. Part 3. This is the Assam Police Manual, my lord.
Yes.
Then after that, my lord, paragraph 31, my lord. Be that it may, this court is of the view that even if the inquiry is held to be done in accordance with law, acting on the same by the disciplinary authority before giving a reasonable opportunity to the petitioner to submit his reply to the said report is not in accordance with law, and accordingly the same is interfered with. The court also finds that the discharge is not being one of the prescribed penalties cannot be imposed on an employee under the rules of 1964. Accordingly, the impugned penalty of discharge dated 35/2012 is interfered with and set aside. Consequently, the order dated 2011-12 of the rejection of the Department Appeal also stands set aside. The petitioner is directed to be reinstated in service, my lord. So I placed my case on these two judgments, my lord. Babul Hussain and
When you were discharged, you were still under suspension?
yes, my lord. He was under suspension, my lord.
Are you sure?
Because page 26 is placed under suspension with effect from 11/12/15 for his unauthorized overstaying leave. Page 26, my lord.
Yeah.
That is the suspension order.
That is there, that is the suspension order.
Yes, my lord.
But when you were discharged, was this suspension in operation?
Yes, my lord, because it doesn't show, it's anywhere say that I have been,
No, you better take proper instructions because this court has to pass an order.
yes, my lord.
What
Alright.
after this suspension order,
Yes, my lord.
all issues are closed. Now only point this court wants to know if
Yes.
this court has to interfere with that discharge order.
Yes, my lord.
Now, this court wants to know whether you were under suspension when you were discharged.
It may be taken up at 2, my lord. I'll get the instructions.
Yes.
I will, Lordship, I would also like to take instruction on that point, Lordship. Lordship, kindly fix the matter some other day, Lordship.
At 2, my lord, I'll get the instructions. Over phone, I have to get.
Can you get your instructions for two?
Lordship, next is Lordship. You see,
It can be taken up at 2, my lord. It is only over phone.
Can you try?
sure, Lordship, I can try, Lordship, but Tuesday, if it could be fixed, Lordship, then we. Lordship.
Okay, but SP, SP county, isn't it?
S count, my lord.
S count. Let me count for the city. Also heard MS,
8 allotted.
8 allotted, then the governor advocate, appearing for the respondent. So. On request made by 8 allotted, then the governor. List the matter again on 19th.
Lordship.
To enable her to take instructions as to whether the petitioner was still under suspension when the discharge order was passed. So, list on 19th as part of.
Yes, sir.
Otherwise, see, there are two issues. You've got the records. You can go through the records in uprising court. Assam manual, no discharge. And the departmental proceeding, no witness examined. So documents could not be proved. You cannot prove a document without examining witnesses.
Lordship.
These two issues only.
Lordship, on Tuesday, I will apply the court, Lordship. Deeply obliged, Lordship.
11.
Arcade Deputy is still in the court, my lord. At 2, my lord. At 2, my lord. Obliged.
16.
I'm sorry, my lord. When the matter was called, I was not present. You have put the respondents for,
4, 5, and 8, your lordship.
and the other respondents are,
The other respondents will be represented by different set of counsels. In fact, your lordship, I'll be relying on my senior's petition on few aspects to be pointed out before the.
civil supplies.
Yes, your lordship.
Who appears for civil supplies?
My petition?
Yeah, Pring? You're ready for the case? Why?
One of my friend lordship, I will call him. And we started, and then I will call.
No, I don't want to keep all matters parted after hearing.
They can start and call.
No, if he's prepared or if he or she is prepared, get the instructions and come back.
But it should not happen. That's why, my lord, I finish my argument and then they keep on looking for the lawyers.
That is the problem.
That should not happen. I thought I missed the bus. I was late.
I already
Now,
passed orders.
That's why, my lord, in fact, I'm sorry. I'm extremely sorry for that. I never thought item 16 will reach so fast. But now it seems that no one is ready. You are prepared. Other lawyers.
Who's the counsel? CKS Barwa.
And who are the other advocates for the respondents? For all the respondents, MK Chaudhary.
No, I'm with the 3, 4, 5, and 8.
4, 5, and 4 is the main respondent.
Yes, he's the first.
Yes.
You are for 4, 5, and
8, your lordship.
8. How about the other respondents?
My lord, in fact, if the 4, 5, and 8 are represented, that would suffice the purpose because
The arguments will likely be the same, your lordship. We are on the same boat and.
all of them are on the same boat. We want our seniority just above respondent 4. He is the immediate junior. Naturally, what else?
4, 5, and 8. No, I don't. It's not. I don't. 16. If I may submit, your lordship, the private respondent's submission will be in sync with the government submission. Is subject to certain variations that might come from their side. So if a learned senior starts, I am prepared with the brief.
No, you may be prepared. I don't know whether government is prepared.
Yes.
My lord, it seems that the council is coming, so I think I may begin. This is what they say.
Yes.
Very well. Lordship may have a look at the list of hits with brief facts. You also may have it.
Thanks.
Now, my lord, the chart, the list of dates begin with the chart. In the chart at serial number 1 to 8, they are the petitioners before the Honorable Court. They are the petitioners before the Honorable Court. Now, among these petitioners, the petitioner number 3, M. Rahman, He passed away during the pendency of this case, 29/1/2020. He passed away, so other 7 are left. Now, my lord, we have shown the date of joining as LDA.
Yes, 1 minute. CKS, are you ready?
16, no?
Yes. Totally disoriented.
May kindly take out after 5 minutes.
5 minutes counsel is here. I want to know whether you're ready or not.
Also, actually,
If you are not ready, then what's the point of hearing the
no,
senior
Lordship,
counsel?
thing is that, Lordship, I have gone through the file, Lordship, but. No, no, particularly. Lordship, that is the reason, Lordship. I can tell after 10 minutes, Lordship. Or Lordship, may kindly fix the matter on Tuesday, Lordship. Do it.
Tuesday I can't fix. No, too many matters are fixed on Tuesday. It has to go to April.
Oh, Lordship, there is a fundamental difficulty, Lordship, because the matter which I have sent, Lordship, it does not tell you it what's been listed, Lordship.
It doesn't tell me?
Okay,
Fine, it's someday. Well, let it be then after 2 weeks. So much of.
Lordship, yes, Lordship, I can submit.
You can make your submission?
Yes, Lordship. In fact, Lordship, yesterday I have gone to the matter. And we have filed an affidavit, Lordship, on behalf of Food and Civil Supplies, Lordship. Here, Lordship, first thing is that, Lordship.
No. Submission has not started.
Okay, then let it start,
This
Lordship.
court wants to know whether you are prepared.
I'm prepared.
Very well. Yes, okay.
Fine.
So, my lord, the chart I was referring to, the second column I have shown the respective dates of joining of the petitioners as LDA and junior assistant in the supply branch. Because, my lord, this is the feeder cadre. This is the feeder cadre for the next higher post of sub-inspector of food and civil supplies. Now, they acquired eligibility on completion of 5 years of regular service in the cadre of LDA and junior assistant. So, in the third column, I have shown the respective dates. They completed their qualifying length of service of 5 years, the respective dates. So there, my lord, will find December 2006, 2003, 2011, 2010. Earliest is 2003 and the last is 2011. So quite long back, they completed their eligibility. So this is it, the third and the fourth column. Now, my lord, the next. Recruitment to the cadre of Sub-Inspector Food and Civil Supplies is governed by the Assam Supply Service Rules 1970. There are 2 amendments of 89 and 2000. I'll come to that later on. Now, under Rule 11 of the rules, the recruitment to the cadre of Sub-Inspector Food and Civil Supplies is made 75% by direct recruitment and 25% by promotion from the select list prepared for this purpose under Rule 13, Sub-Rule 3, from amongst feeder ministerial cadre comprising of lower division assistant, junior assistant, account assistant junior in the Office of Director, Food and Civil Supplies and Consumer Affairs, and Food and Civil Supplies offices in the district and subdivision of Assam. Now, I'm not pausing here, I clarify. Here we are dealing with the seniority dispute between direct recruit and the promotees. The petitioners before this honorable court are the promotees, and the private respondents are the direct recruit. This is a seniority dispute in the cadre of Sub-Inspector of Food and Civil Supplies. The petitioners who are promotees are seeking the fixation of their seniority above the private respondents, the direct recruits. That's the core of the case. So, my lord, the quota is 25% by promotion and 75% by direct recruitment. Next, page 2, my lord. Under Rule 11 of the rules amended in 1989, the 25% earmarked quota of promotees in the cadre of Sub-Inspector of Food and Civil Supplies shall be filled by promotion from the select list prepared for this purpose under Sub-Rule 3 of Rule 13 from amongst the ministerial cadre who are of outstanding ability and who have rendered at least 5 years of continuous service in the ministerial cadre on the first day of the year in which the selection for promotion is made. I'm referring to the relevant rules. Next is the Rule 11 Sub-Rule 2 provides that the ministerial cadre for such promotion shall include the post of lower division assistant, account assistant junior in the office of the Director, Food and Civil Supplies, and the Food and Civil Supply offices in the district and subdivision. So, my lord, this is the feeder cadre, and the petitioners belong to the feeder cadre. In 2006, there was a sitting of the DPC for making promotion to the post of Sub-Inspector, Food and Civil Supplies, and it recommended promotion of 4 persons. After the 2006, I have referred to because, my lord, this was practically the last DPC before the DPC in question. In between, there was long interval, long gap. So 2006, the promotions were made. 2 years later, on 16th August 2008, advertisement was issued for direct recruitment against 145 vacancies in the cadre of Sub-Inspector, Food and Civil Supplies. Since no direct recruitment in the cadre of Sub-Inspector, Food and Civil Supplies was made after 91, it is presumed that 145 advertised vacancies under direct recruit quota were accumulated over a period of more than a decade. So, in 2008, below they had issued advertisement for direct recruitment. In 2006, the promotions were made. Then, my lord, we come to May 2011, straight away. In May 2011, process was initiated under Rule 11 Sub-Rule 2 of the rules to fill up the promotion quota of 14 vacancies. So, after 2006, 5 years later in 2011, again the process was initiated to fill up the promotion quota of 14 vacancies. 20th January 2012, the government of Assam issued a notification constituting a selection committee which was to hold its meeting on 14/2/2012. Then 22nd May 2012, select list was published comprising the names of 145 direct recruits. Now, my lord, again we jump to the direct recruits. In the meantime, my lord, the process was initiated for making promotion. That process was continuing. But, my lord, the selection committee was also to hold its meeting on 14th February 2012. But in the meantime, on 22nd May 2012, select list was published comprising the names of 145 direct recruits. 19/6/2012, order was issued appointing 130 direct recruits as Sub-Inspector Food and Civil Supplies. These direct recruits also included Respondent 4 to Respondent 11. Over a period of time, only 117 direct recruits were left in the service, including the Respondents 4 to 11. So, 19th June 2012, the order was issued, appointing 130 direct recruits, and over a period of time, only 117 were left. So far as, my lord, the promotion quota is concerned, the process was initiated in May 2011 under Rule 11(2). The selection committee held its meeting on 14th February 2012, and thereafter nothing happened. But in the meantime, the process of direct recruitment was completed, and they were appointed in the year 2012. Then comes 1st August 2012. Since meeting of selection committee could not be held on 14th February 2012, that is for the promotion quota, the Director, Food and Civil Supplies and Consumer Affairs wrote a letter to the Deputy Secretary, Government of Assam, Department of Food and Civil Supplies and Consumer Affairs, asking about the date and time for next meeting of the selection committee. So that process is continuing. Then 12/10/2012, Director, Food, Civil Supplies and Consumer Affairs wrote a letter to the concerned officer which reveals that it was decided to hold the meeting of the selection committee on 18/10/2012, but on that date the meeting was not held. That is how, my lord, the delay is taking place in finalizing the selection of the promotees. 21/12/2012, WT message was issued containing the names of all the eligible candidates under the zone of consideration for promotion to the post of sub-inspector food and service supplies. It was decided to hold the meeting of selection committee on 26/12/2012. Then comes yet another date, 26/12/2012. After a gap of 5 years, a DPC was held, which recommended promotion of 11 persons to the post of sub-inspector food and service supplies, which included the present petitioners. So, my lord, finally, it is 26th December 2012, the DPC recommended promotion of 11 persons. So, what we find is the first date is May 2011, when process was initiated for filling up the promotion quota, and the process which began in May 2011, finally the DPC recommended in 26th December 2012. But it's only a recommendation. Recommendation has not been acted upon till now. I'll come to that. Now, before that, I'm just showing the vacancies. At present, the total strength of the cadre of sub-inspector food and service supplies is 249. Since 75% of the total cadre strength of 249 has to be by way of direct recruitment, there are 187 posts for direct recruits, whereas 62 posts are meant for promotees. Now, Lordship will see the vacancy. 2006, Milord, I have already pointed out that in 2006, there were 9 vacancies. DPC was held, and pursuant to the recommendation, 4 were promoted to the cadre of SI, FCS, Sub-Inspector, Food and Service Supplies and Consumer Affairs, thereby leaving 5 vacancies in the said cadre. So in 2006, when the promotion were made, only 4 posts were filled up, the 5 vacancies were left. Those 5 vacancies were carried forward. 2007 vacancies carried forward, 5. But there was no DPC. 2008, no DPC. 2009, 9 more posts in the promotion quota fell vacant. When 9 more posts fell vacant, 9 plus 5, it became 14. So 2009, there were 14 vacancies. 2010, 14 vacancies carried forward because there was no DPC. 2011, again no DPC. 14 vacancies remained. 2012, finally, the DPC meeting was held on 26/12/2012, and it recommended 11 persons for promotion. So out of 14, 11 were recommended. And next year, since there were 3 vacancies, 11 persons, though recommended by DPC in the year 2012, but were promoted by order 20th June 2013. So, my lord, the 3 more, in fact, were promoted. The 11 persons, though recommended by DPC in the year 2012. Oh, yes, I'm sorry. I'm correcting myself. It's like this. In 2012, my lord, the DPC was held, and out of 14, it recommended 11 persons to fill up the as many 11 vacancies. But those 11 vacancies finally were filled up only in the year 2013, which is the last column. That is by order of 20th June 2013. By order of 20th June 2013, the recommendation of DPC was accepted and formal appointment orders were issued. That is the DPC, my lord, which made the recommendation in 26th December 2012. That recommendation culminated in the order dated 20th June 2013. Now, my lord, what is the significance? I'm clarifying some one thing. What is the significance of 20th of June 2013? My lord, the significance of 20th June 2013 lies in the fact that on the one hand, we have the direct recruit. In the case of direct recruit, my lord found that in 2012, they were appointed formally. So far as the promotees are concerned, though process was initiated in 2011, but only on 20th of June 2013, they could be promoted and appointments are issued. Now, my lord, under the rule says if direct recruits and the promotees are appointed in the same year, then promotees will get their seniority over the direct recruit of that year. Now, my lord, had these promotees could be formally appointed in the year 2012 itself, as my lord has noticed, DPC recommended on 26th December 2012, pursuant to the process initiated in May 2011, had the order of 20th June 2013 came out in 2012 itself, promotees and direct recruit would have been in the same year. And had they been in the same year, the promotees would have got their seniority over the direct recruit of that year. That is the mandate of Rule 32, Sub Rule 6. I'll come to that. Here is a case where rule, the way it is, was to the advantage of the direct recruit because the promotees could not be appointed in the year 2012. Now, my lord, the only issue for the consideration of a lordship will be in the present case as to whether it was due to the laches on the part of the state respondent that promotees could not be appointed in the year 2012. If my lord finds that there is a significant delay in completion of the process, then, my lord, I will be seeking equity from this honorable court. And there are precedents and judgments to that effect. Because process you initiated in May 2011. DPC gives its recommendation in 26th December 2012. Even then, you take literally more than 6 months to appoint these very people against the promotion quota. As a result, those very people who could be appointed in the year 2012 comes to be appointed, my lord, in the year 2013. Therefore, what happened in the case was these direct recruits, 117 of them in toto, they were given seniority over the petitioners on the ground that the recruitment of direct recruits was on a prior year, promotees were appointed on a later year in the year 2013. I'll complete the list of dates. Then 18th June 2013, after an inordinate delay, the government of Assam communicated the decision of personal department dated such and such to the director, Food and Civil Supplies and Consumer Affairs towards implementation of the recommendations of selection committee dated 26/12/2012. Then comes the date which your lordship has already seen, 20th of June 2013. Director Food and Civil Supplies and Consumer Affairs issued an order formally appointing 11 ministerial staff, including the 8 petitioners under promotion quota, to the cadre of Sub-Inspector Food and Civil Supplies. So 20th June 2013 is the date. Then 21st June 2013 to 4/7/2013 on various dates during this period, the petitioners joined as Sub-Inspector Food and Civil Supplies. 13/8/2014, Director Food and Civil Supplies and Consumer Affairs circulated the provisional gradation list in respect of 175 Sub-Inspector Food and Civil Supplies, both direct recruits and promotees. All the concerned officers were called upon to make claims and objections in respect of the position assigned to them in the inter-se seniority list. In this list, the promotees, including the petitioners, were placed between serial number 165 to 175 below the 119 direct recruits who were placed at serial number 40 to 164. Then 15/9/2014 to 16/9/2014, petitioner 2, Manohari Bayan, petitioner 4, Satyajit Sabha Pandit, petitioner 7, Vinod Chandra Sharma, and petitioner 8, Madhav Burman, submitted their objections on 15/9/2014 in respect to the position assigned to them in the provisional seniority list. Petitioner 6, Zainul Abidin, submitted his objection on 16/9/2014. May not all these objections we have annexed with the paper book. I have given the serial numbers. 3/3/2015, Director Food and Civil Supplies and Consumer Affairs issued an order publishing the first phase of final gradation list consisting of 41 sub-inspectors, both direct recruits and promotees. This list was issued because there was no dispute about the position assigned to them. So far as, my lord, the first list is concerned, there is no quarrel, no dispute whatsoever, because both promotees as well as direct recruits, they are senior to all. So, my lord, nobody is making any objection against them. Nobody is claiming seniority over them. So this list is beyond dispute. Then comes 2010-2017. Director Food and Civil Supplies and Consumer Affairs circulated another provisional gradation list of Sub-Inspector Food and Civil Supplies, both direct recruit and promotees. In this list, the promotees, including the petitioners, were placed from serial number 121 to 131 below the direct recruits, who were placed at serial number 4 to 120 of the list. The concerned Sub-Inspector Food and Civil Supplies were called upon to make claims and objections with regard to the positions assigned to them, latest by 2011-2017. So again, a provisional gradation list came and we were called upon to submit our objection. May not be submitted our objections. That is the next date, 17/11/2017. Petitioners filed their objections with regard to position assigned to them in the provisional gradation list. All the objections were annexed. 14/5/2018, WT message was issued by Joint Director in charge, Directorate of Food and Civil Supplies and Consumer Affairs, inviting the petitioners for personal hearing on 18/5/2018 in respect of their objections. Then 30/11/2019, my lord, this is impugned under challenge before the Honorable Court. After hearing the petitioners on 18/5/2018, the respondent 3, Joint Director in charge, Directorate of Food and Civil Supplies and Consumer Affairs, issued separate orders rejecting the claims and objections of the petitioners, holding that though the selection committee had recommended the petitioners for promotion in the year 2012, that is 26/12/2012, that is the date, my lord, when DPC gave its recommendations. But they were appointed only on 20th of June 2013. And as such, the petitioners cannot claim seniority over the direct recruits who were appointed in the year 2012. For this view, reliance was placed on Rule 32, Sub-Rule 6 of the rules as amended in 2000. So separate orders were there, my lord, in respect of the petitioners. So, my lord, I'll just impugn the orders. I will read later on. I'll complete the list, my lord, first. Then is the second date, 20th of June 2019. Director, Food and Civil Supplies and Consumer Affairs published the final gradation list of sub-inspector, Food and Civil Supplies, both direct recruits and promotees. In this final list, the petitioners and other promotee sub-inspectors were placed at serial number 120 to 130, and the direct recruits were placed above them. This is also impugned because this is the final seniority list of DR and promotees. 16/7/2019, petitioners filed WPC, the presented petition they filed, assailing the order dated 31/2019, and the final gradation list of Sub-Inspector Food and Civil Supplies dated 28th of June 2019, which is, my lord, Annexure 14. Both were challenged in the presented petition. 22nd July 2019, the Honorable Court, while issuing notice, passed an interim order that any promotion made to the post of Sub-Inspector in the Department of Food and Civil Supplies and Consumer Affairs during the pendency of the case shall be subject to the outcome of the case. So, my lord, this interim order was passed, and after the interim order, on 29th January 2020, petitioner 3, when he dies, my lord, that date I have already given, not relevant. I'll come to the next, page number 10. 23rd of June 2020, Director Food, Civil Supplies and Consumer Affairs called upon all the eligible sub-inspectors to submit their ACRs within 10 days for consideration of the same for promotion to the next higher post of Inspector Food and Civil Supplies and Consumer Affairs. During the pendency of the case, my lord, many of them became eligible for the next promotion to the post of Inspector. So, my lord, the ACRs were called upon, there was a direction to submit the ACRs. 14/8/2020. I'm sorry. Yes. Already pointed out that there was an interim order of this Honorable Court to the effect that during the pendency of this case, if any promotion is made to the higher post of Inspector of Food and Civil Supplies, then that will be subject to the outcome of the case. Now, the reason was very simple because, my lord, the petitioners, the private respondents, the direct recruit, on account of their higher seniority in the cadre of sub-inspector, they were coming within the zone of consideration much earlier than the promotees who were down below. So, my lord, during the pendency of the case itself, they became eligible. They came in the zone of consideration, the private respondents, and accordingly, my lord, the next date is 14/8/2020 at page 10. A departmental selection committee meeting was held and it suggested candidates for promotion to the post of Inspector Food and Civil Supplies and Consumer Affairs. 29/9/2020, consequent to departmental selection committee meeting dated 14/8/20, the government of Assam Food and Civil Supplies and Consumer Affairs temporarily promoted the selected direct recruit sub-inspectors to officiate. So, my lord, because of the interim order of the Honorable Court, officiating promotions were given to officiate as Inspector Food and Civil Supplies Consumer Affairs until further orders. It was also clarified in the said notification that the officiating promotion so granted shall be subject to the outcome of the writ petition of the petitioners, referring to the presented petition. Then 12/1/2021, we filed an affidavit and we brought on record the first 3 dates, that is annexure 15, 16, and 17, by way of an affidavit. Then 24/12/2021, a departmental selection committee meeting was held, which recommended promotion of 37 numbers of sub-inspector food and service supplies and consumer affairs to the next higher post of inspector. It should be inspector food and service supplies and consumer affairs, not sub-inspector. It's a typographical error, my lord. I'm sorry. These 37 numbers of sub-inspectors also included petition number 2, 4, 5, 6, 7, and 8. So, my lord, the DPC dated 24/12/21 also recommended the petitioners for promotion to the post of inspector food and service supplies. That was after 1 year, practically after 1 year, because in 2020, my lord, the respondents were promoted. 7/5/22, Food and Service Supplies and Consumer Affairs Department, Government of Assam, dated such and such, promoted the petition number 2, 4, 5, 6, 7, and 8. Formal orders of promotions were issued in respect of the petitioners. Again, my lord, they were also given the officiating promotion. We filed an affidavit. So these are, my lord, the relevant dates. The other things, my lord, I will point out later. Straight away, my lord, first of all, I will take your lordship to the impugned orders which were passed on our objections, on the objections filed by the petitioners. Namely, because the issue remained, my lord, the petitioner said, look here, in our case, we could be promoted to the cadre of sub-inspector food and civil supplies from the feeder cadre in the year 2013, primarily because of the laches on the part of the state respondents. Had DPC meeting taken place in the year 2012, had DPC meetings recommendations of 2012 were acted upon by the state respondent in 2012, then we also, like the direct routes of 2012, would have been appointed in the year 2012 itself. And had we been appointed in the year 2012, we, the promotees, as well as direct recruits who are of 2012 appointees, would have been of the same year. And in such a situation, as per the mandate of Rule 32, Sub-Rule 6, promotees would have got seniority over the direct recruits. The submission further is, if the mandate of Rule 32, Sub-Rule 6 is coming to the advantage of direct recruit for the purpose of fixation of their seniority over the promotee, is principally because of the laches on the part of the state respondents. If the state respondent takes the plea of mandate of Rule 32, Sub-Rule 6, the question I'm asking myself is, you are taking this plea principally because of the wrong committed by you. You are trying to take advantage of your own wrong. You delay unnecessarily. You keep on sitting over the file. The DPC recommendation was of 26th of December 2012. You kept on waiting for more than 6 months and finally promoted us in 2013 June. You are responsible. You can't take advantage of Rule 32, Sub-Rule 6, saying that this is the mandate of the rule. The question of mandate would not have arisen had you acted on the right time. So the issue is, are we entitled to take advantage of a situation which is of the creation of the state? Or should we be the victim of the laches on the part of the state by becoming junior to the direct recruits? That is the issue for the consideration of a lordship. Now I'll come to the impugned order. All the orders are verbatim similar, so below I will refer to only one. That is Annexure 13A, dated 30th of January 2019. The page number, my lord, is 121 of the paper book. Page 121, my lord, I read order passed by joint director. I hope my lord has got it.
Yeah.
Peruse the petition submitted by Abdul Aziz Khan. He is the petition number 1, in fact. In connection with the provisional gradation list circulated by this Directorate of Food and Service Supplies and Consumer Affairs, Assam wide number such and such. The petitioner wide his letter dated such and such has objected against the position at serial number 131 assigned to him in the aforesaid provisional gradation list and claimed for placement above Shri Abdul Kalam Azad, who has been placed at serial number 4 in the provisional list selected and appointed through direct recruitment in the year 2012. The undersigned has issued a WT message number such and such dated 14/5/2018 for personal hearing on 18/5/2018. On getting the above WT message, the petitioner did not attend this directorate on 18/5/2018 for personal hearing. I, such and such Joint Director, Food and Service Supplies and Consumer Affairs, Assam, has gone through the petition and personal hearing, and it is found that although selection committee has recommended the name of petitioner to be promoted as sub-inspector on 26/12/2012, minutes prepared on 26/12/2012, but the authority concerned, the then Director, Food and Civil Supplies and Consumer Affairs, had issued appointment order on 20th of June 2013, and the incumbent had joined in service as sub-inspector on 21st June 2013. As per Rule 32 Sub-Rule 6 of the Assam Food Civil Supply Services Amendment Rules 2000, the petitioner's claim is hereby rejected. So, my lord, it is a mandate of Rule 32 Sub-Rule 6. All the orders are verbatim similar in respect of all these petitioners. They are placing reliance on Rule 32 Sub-Rule 6. Next, my lord.
Let us have a look at the.
I'll come to that. Only one more document I will show to your lordship, then I'll come to the rule straight away. Now, my lord will see the select list, the final select list, which is 20th June 2019. It begins at page 129 of the paper book. Page 129 of the paper book. The relevant page is page 130, my lord. The very first page itself. I'm just showing the. At serial number 3, my lord will find Abul Kalam Azad. He is the first direct recruit at page 130. 130. Abul Kalam Azad at serial number 3 is the first direct recruit. All the petitioners are claiming seniority just above Abul Kalam Azad. He is immediate junior. So far as the petitioners are concerned, my lord, in fact, my lord, I have made parties from Abul Kalam Azad to serial number 10, Gautam Chakravarti. All these persons, all these are respondents from serial number 3 to serial number 10. My lord, we have not made all the direct recruits, apparently approximately 117 or 119 a party, because my lord, placing reliance on Pramod Verma's case, we have taken the senior most group. Once, my lord, because these groups can.
No, Pramod Verma's case is a different thing.
My lord, in Pramod Verma, argument was whether all of them should be made a party. The court said if some of the persons can be made a party, they can represent as a class the rest of the people. Because if my claim against Abul Kalam Azad succeeds, he is the senior most of the direct recruit. Others cannot have a different say than the Abul Kalam Azad. Abul Kalam Azad is being heard, and along with him, other senior most respondents are being heard from 3 to 10. Entire group is being heard. Once I succeed against them, I succeed against the rest. The argument is not different. I'll place that also. Pramod Verma's citation. That is the principle, my lord. I need not make all the respondents a party, 119 of them. They need not be heard. The senior most are being heard as a class. They represent the rest. So far as, my lord, we are concerned, lordship will find our name at page 137, the last page, at serial number 120. The first of the petitioner, Jainal Abidin.
Serial?
Serial number 120. 120 to 130, 120 to 130. They are all promotees. Abdul Aziz Khan, petitioner number 1 is 130, the last. So these promotees, my lord, they are claiming their fixation of their seniority above Abul Kalam Azad. He is the immediate junior, according to them. The direct recruit of 2012, the first.
Our old is from 119, from serial number 3 to 119.
Yes, my lord.
These are direct recruits.
Yes, all are direct recruits. All are. Huh? Yes, 2012. All those who are up to 2012 batch, my lord, fine, till serial number 119. 25/6/2012 is the date. So far as 119 is concerned. All of them are of 2012 batch. We are 2013 batch. Though the process of initiating promotion started in the May 2011, but could be culminated only in the year 2013, June 2013. Pramod Verma I have brought, I believe. Yes, I have brought. Just to satisfy your lordship, I'll straight away, I'll show the rule 32.6 first. Though, my lord, I have annexed the entire rules, it is part of the paper book, but for the sake of the clarity, the rule 32 I have typed separately. Lordship may have a look.
Where are the rules in the paper book?
Yes, all the rules are there in the paper book with amendments, but my lord, I have typed separately for clarity. The rules in the paper book, my lord, will find page 25 to 41. And rule 32 sub rule 6, my lord, will find at page 33 of the paper book.
Yeah. On page
33, this was amended actually. This was amended, so that's why the amended portion, entire thing I have typed. This was 2000 amendment. The relevant amendment is at page 40. Page 40, I have annexed the entire amendment of 5th May 2000, amending the rule 32 sub rule 6. It was inserted at page 40. And typed portion I have given to your lordship, I have got the entire thing typed out. The amended rule. So for the sake of clarity, my lord may see this. The typed portion. Because amendment of 2000 is separate. It is at page 40. Insertion of new sub rule 6. Earlier below sub rule 6 was not there. It was brought in by way of amendment.
Yes.
32 sub rule 6 reads, the inter-se seniority of sub-inspectors of food and civil supplies appointed under sub rule 2 of rule 11. Now, my lord, sub rule 2 of rule 11, it provides methodology of promotion. So it's meant for the promotees. Promotees are appointed under sub rule 11, rule 11 sub rule 2 shall be fixed over the sub-inspector of food and civil supplies appointed under sub rule 1 of rule 11. Rule 11 sub rule 1 pertains to direct recruit. Entry through direct recruitment. Rule 11 sub rule 2, entry through promotion. So the inter-se seniority of sub-inspector of food and civil supplies appointed under sub rule 2 of rule 11 as amended shall be fixed over the sub-inspector of food and civil supplies appointed under sub rule 1 of rule 11 as amended if promotion and direct recruitment take place in the same year. So, my lord, if the promotion and direct recruitment take place in the same year, promotees will get their seniority over the direct route of that year. So the only issue for the consideration of
what is the definition of year?
Definition, my lord, so far as the rules are concerned, my lord, the rules are silent about the definition of the year.
No, there is.
Well, just a minute, I'll come to this.
Page
Yes,
26.
yes. Just a minute, Here, my lord, is defined. Yes, I'm sorry. Yes, just a minute. Service recommendation. Year means the calendar year. It's, my lord, just like any other year, my lord, in all India services also they say year is a calendar year. That is January to December. It's neither here nor there. So, my lord, it does not help us in any manner. It helps no side. Now, my lord, I take it, yes. Year is what? Year is 2012, direct recruits were appointed. There is no dispute about that. So far as promotees are concerned, they were appointed in the year 2013. Now, our argument is, we could have been easily appointed in the year 2012, but for the fault of on the part of the state government, we could not be appointed. Now, my lord, if on the facts of a given case, my lord is satisfied that there is no reasonable explanation on the part of the respondents for delay in appointing these promotees in the year 2012 itself, then in such a situation, what would the my lord, what relief my lord will give me? That is the issue for consideration. And my lord, it is not the first time the honorable courts have dealt with this aspect. And there are judgments to the effect, and I'll be placing the judgments. There are judgments to the effect that in such a situation, if the laches are on the part of the state can't take help of its own laches and then take recourse to law and say, look, this is what the law is, and you will be getting seniority like this. If laches are on the part of the state, then the retrospectivity has to be given to the promotion, so as to give them what they have lost because of the laches on the part of the state. Here, my lord, is a case where in May 2011, the process was initiated. And my lord, the sitting of the DPC was also delayed substantially. It was on 26/12/2012. But finally, my lord, the appointments were made after 6 months in June 2013. There is no justification for that, and no justification is coming even by way of an affidavit from the state respondent. I'll come to the case laws now, my lord, on the subject, how the courts have dealt with this issue. But before that, my lord's query on Prabodh Verma case, I'll just place that. Why I am not required to bring all the respondents. 84/4 SCC, page 251. The relevant para, my lord, is para 28. At page 273. Para 28, my lord, may I read? The real question before us, therefore, is the correctness of the decision of the High Court in the Sangh case. Before we address ourselves to this question, we would like to point out that the writ petition filed by the Sangh suffered from two serious, though not incurable defects. The first defect was that non-joinder of necessary parties. The only respondent to the Sangh petition were the state of Uttar Pradesh and its concerned officers. Those who were vitally concerned, namely the reserve pool teachers, were not made parties, not even by joining some of them in a representative capacity, considering that their number was too large for all of them to be joined individually as respondents. The matter therefore came to be decided in their absence. A High Court ought not to decide a writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondent, or at least by some of them being before it as respondents in a representative capacity if their number is too large. You know, these are the lines I'm emphasizing upon. And therefore, the Allahabad High Court ought not to have proceeded to hear and dispose of the Sangh's writ petition without insisting upon the reserve pool teachers being made respondents to that writ petition, or at least some of them, being made respondents in a representative capacity, and had the petitioners refused to do so, ought to have dismissed that petition for non-jointer of necessary parties. So, my lord, it is not the case. Numbers are too large here. I have brought the senior most of the direct route before the Honorable Court by making them parties. Once, my lord, I succeed against them, I succeed against all. So that way, my lord, they are represented. That's my submission, placing reliance on Pramod Verma. Now, my lord, I'll come to the next question, namely, the mandate of Rule 32, Sub-Rule 6. And the argument, if laches are on the part of the state, and because of the laches on the part of the state, if the petitioners do not get promotion at the right time, so as to get the benefit of the seniority over the direct route of the same year, then what should be the relief, my lord, which the petitioner would be entitled to, or whether the Honorable Court give them relief. Now, my lord, for this, my lord, the first judgment which I am referring to, first of all, my lord, I will refer to the principle that a man cannot be permitted to take undue and unfair advantage of his own wrong to gain favorable interpretation of law. I'll come to that later. State away, P.N. Premchandran versus State of Kerala, 2004, 1 SEC, page 245. If my promotion gets delayed for the laches of the state, then what benefit should I get? 2004, 1 SEC, 245, P.N. Premchandran versus the State of Kerala. Para 7 and para 8 would be relevant paragraph, my lord. The relevant page, my lord, is page 248. I begin, my lord, para 7, page 248. It is not in dispute that the posts were to be filled up by promotion. We fail to understand how the appellant, keeping in view the facts and circumstances of this case, could question the retrospective promotion granted to the private respondents herein. It is not disputed that in view of the administrative lapse, the Departmental Promotion Committee did not hold a sitting from 1964 to 1980. The respondents cannot suffer owing to such administrative lapse on the part of the State of Kerala for no fault on their part. It is also not disputed that in ordinary course, they were entitled to be promoted to the post of Assistant Director. In the event, a Departmental Promotion Committee had been constituted in due time. In that view of the matter, it must be held that the State of Kerala took a conscious decision to the effect that those who have been acting in a higher post for a long time, although on a temporary basis, but were qualified at the time when they were so promoted and found to be eligible by the Departmental Promotion Committee at a later date, should be promoted with retrospective effect. So, promotions were given the retrospective effect by the state because of this situation. And those who were the victim of this promotion given to the other side went to the court. The court said it was perfect. Next para. Such exercise of power on the part of the state is not unknown in service jurisprudence. Even assuming that such a power did not exist in Rule 31 of the rules, the same can be traced to Rule 39 of the rules as noted herein before. It is relevant to note in a Janardhan versus Union of India, this court held as under. But avoiding any humanitarian approach to the problem, we shall strictly go by the relevant rules and precedents and the impact of the rules on the members of the service and determine whether the impugned seniority list is valid or not. But having done that, we do propose to examine and expose an extremely undesirable, unjust, and inequitable situation emerging in service jurisprudence from the precedents, namely that a person already rendering service as a promotee has to go down below a person who comes into service decades after the promotee enters the service and who may be a schoolian, if not in embryo, when the promotee on being promoted on account of the exigencies of service as required by the government started rendering service. A time has come to recast service jurisprudence on a more just and equitable foundation. by examining all precedents on the subject to retrieve this situation, unquote. So practically, my lord, this is how the court looked at it. Then I'll come to, my lord, the other case, namely that one can't be permitted to take undue and unfair advantage of one's law to gain favorable interpretation of law. That is Kusheshwar Prasad, 2011, 2007-11 SEC, page 447. Relevant para 60. 16. The short paragraph, my lord. The court explained the legal principle. It is settled principle of law that a man cannot be permitted to take undue and unfair advantage of his own wrong to gain favorable interpretation of law. It is sound principle. It is sound principle that he who prevents a thing from being done shall not avail himself for the non-performance he has occasioned. To put it differently, a wrongdoer ought not to be permitted to make a profit out of his own wrong. Because, my lord, the plea of the state is very clear. 32 sub rule 6. That is the mandate. We have followed the mandate. You will be below the direct recruit of 2012 because they are 2012. You are 2013. The counter question immediately is, how come I am 2013? I am 2013 because of you. Had you wanted, you could have appointed me in 2012 itself. Number one, you delayed the DPC unreasonably. For few years, there was no DPC at all. The vacancies were carried forward. Finally, the DPC sat in the year 2012 itself, 26th December, very late. But my lord, even in 4 days, we have seen recommendation of DPC being acted upon in 24 hours. We have seen that. They could have, had they acted upon the recommendation of DPC, DPC gave the recommendation on 26th December, 27, 28, 29, 30, 31st. Had the order been passed on 30th, 29th, 31st of December, we would have been the product of 2012. We would have got promotion above the direct recruit in terms of the mandate of Rule 32 sub Rule 6. But what they did, they sat over the recommendation of DPC for 6 months, more than 6 months. It is in June 2013 that they issue the appointments. So that's been deliberate, intentional. Should they be allowed to take cover behind 32 sub Rule 6? That is the question I'm asking myself. And that is an issue my lord has to resolve. Now, my lord, there is a judgment of the coordinate bench. Same, my lord, placing reliance on P.N. Premchandran. It is of Imphal High Court, but not the same principle. They have reiterated, referring to all these cases. The relevant, my lord, I'll come to that. The relevant, my lord, paragraphs are paragraph 20. I'll read those paragraphs. Para 22, I start first. Same judgments of the Supreme Court have been discussed in this case also. Para 22, my lord, to begin with. Internal page 13, 1-3. In the instant case, the petitioner who was given promotion to the post of Inspector of Police in the year 2008 became eligible for promotion to the post of MPS Grade 2 in the year 2010. Had the DPC held in the year 2014-15, the petitioner would have been given promotion in that year, and due to non-holding of the DPC for promotion to the post of MPS Grade 2 for years, in spite of having vacancies in the grade of MPS Grade 2, the petitioner was denied his right for consideration for promotion in time. The arguments of learned government advocate that the appointment to a higher post with retrospective effect from a deemed or notional date of appointment is given most sparingly and on sound reasoning and foundation only when the DPC is found to be arbitrary in nature and the petitioner has failed to prove the same, and therefore the petition is not maintainable, cannot be countenanced, as the respondent authorities have failed to explain the delay in sending the proposal for filling of vacant posts. The only reason cited by the respondent authorities is that, in view of the pendency of the writ petitions, the delay of all promotion process of all subordinate rank officers occurred cannot be accepted since the respondent authorities have failed to produce any material to show that there was an order of the court not to fill up vacancies by promotion and also conduction of DPC. And that is why they have not conducted the DPC in time. Then the next para, my lord, is para 26. The Honorable Court refers to Kuseshwar Prasad principle, para 26. In Kuseshwar Prasad saying, the apex court held it is settled principle of law that a man cannot be permitted to take undue and unfair advantage of his own wrong to gain favorable interpretation of law. It is sound the same thing, not the same para has been quoted. The para 16 of Kuseshwar Prasad. Then, my lord, para 27. In the present case, there was no reasonable ground for not holding the DPC for consideration for promotion to the post of MPS grade 2 in the year 2014-15 against various vacancies available. Therefore, there is a delay on the part of the respondent authorities for not convening the DPC in terms of the office memorandum. The said finding of this court is also supported by the decision of the Honorable Apex Court in the case of P. N. Premchandran. Well, P. N. Premchandran I have already cited before your lordship. The same judgment they have referred. Wherein the Honorable Apex Court observed the delay in convening DPC being administrative lapse, promotees cannot be made to suffer for no fault on their part. In the said case, the Apex Court also held that the appellant therein has no right to question the retrospective promotion granted to the private respondents. Then para 29, another judgment of a coordinate bench of this Honorable Court this time has been referred to. In Oinam Rajasthan Singh, the Guwahati High Court held as under. Para 8 has been quoted. And this I read. Principle of natural justice and prudent logic demands when a person is eligible for a promotion and vacancy is available, he should be given effect of his promotion from the date of his eligibility. DPC could not be held in time, for which, in my view, petitioner cannot be held responsible or victimized for delayed DPC. Therefore, I direct the respondent's authority that the petitioner's promotion be to be given with effect from the date of his eligibility for promotion, that is 1/6/2009, and he to get all the benefit from the date of his eligibility, that is 1/6/2009. We must not forget that a person is not promoted in time. When he becomes eligible, it may adversely affect his further promotion and seniority too, unquote. Then the next para, the aforesaid decisions are squarely applied to the case on hand. It is not the case of the respondents that the petitioner is not eligible for promotion at the relevant point of time. As rightly held, for the non-holding of the DPC at the relevant point of time, the petitioner cannot be held responsible and he cannot be victimized for the delayed DPC. Then the next para. In the instant case as stated above, due to the inaction on the part of the department to take up the process for filling up the vacant post of MPS grade 2 in time, even though the petitioner was recommended against the vacancies of 2014 and 15, he got promoted with effect from 2018 only. That is the date on which his actual promotion to the grade of MPS grade 2 was affected. In fact, the inaction on the part of the department is against the instructions and guidelines framed by the Department of Personnel regarding holding of DPC for promotion. Therefore, in order to compensate the loss of time in affording promotion, it would be just and proper to direct the respondents to afford notional promotion to the petitioner with effect from 2014-15, that is the vacancy year against which the petitioner was recommended. Ordinarily, an employee is entitled to be considered for promotion as per his seniority. If promotion is based on seniority as a matter of course, senior should be granted promotion unless he is otherwise declared as unfit to be promoted. If promotion to be next cadre is based on selection, employees is entitled to be considered as per seniority along with all other eligible candidates by DPC, and if DPC recommends, he is entitled to be promoted. It is also the fact that in case the DPC was held in 2014-15, the petitioner would have completed 5 years of regular service and thus would have become eligible for being considered for the next promotion to the post of MPS grade 1. As per the version of the respondents themselves, there was sufficient number of vacancies in the grade of MPS 2 with effect from 2011 onwards. My lord, pausing here, I submit, in this case also my lord must have noticed that direct recruit, because of their getting appointment in the year 2012, became eligible early, came in the zone of consideration early, and as a result, they were given officiating promotion to the next higher grade of Inspector of Food and Civil Supplies. Because of the interim order of the Honorable Court, the promotion was officiating and was made subject to the outcome of this case. But advantage is always there. There is always, the moment you get an advantage of 1 year, apparently below next stage of promotion, you will get the same advantage. Because you will come in the zone of consideration earlier. We are down below all the 100 people. So below, in our case, a ton will come later. Therefore, to the grade of inspector also, we were given the promotion subsequently. So continuously below, we will remain junior. Para 34. Due to the arbitrary exercise of power in not holding the DPC on time by the authority, admittedly the petitioner will retire below one rank than the one which ought to have been made available during his long career in the department due to want of qualifying service. Therefore, in the interest of justice and in equity, to direct the respondent authorities to give notional promotion to the petitioner with effect from 2014-15. It is reiterated that every employee is having right to seek promotion as a matter of right in his or her service. According to the respondent, there are such and such, such and such. Lastly, below, the relief given is the writ petition is allowed. Respondents are directed to grant notional promotion to the grade of such and such with effect from such and such, and the said exercise is directed to be completed within the period of 3 months from the date of receipt of a copy of this order such and such. But in our case, what we are seeking is, we are seeking the fixation of our seniority just above Abul Kalam Azad at serial number 3. There we want our seniority to be fixed. In the final seniority list, in the cadre of Sub-Inspector of Food and Civil Supplies. Now, my lord, for the benefit of your lordship, by highlighting the delay on the part of the state, I have segregated the relevant dates in the last of the write-up, especially how the delay has taken place. Delay in holding DPC at page 12 of the write-up, my lord will find. We have segregated those relevant dates. And there is no explanation whatsoever, my lord, in the affidavit of the state. Why the delay?
Do we have a guideline with regard to the conducting of DPC in Assam? I think there's.
We have.
You have.
Yes, content of DPC, yes, Lord, sir.
Holding of DPC. You have the copy of the guidelines.
Not right. We have to check in our office to see how DPC is, Lord, sir, basically. So we should have.
In this case, my lord will find the process was initiated in May 2011. That is the first date. But below, as I have shown in the chart itself, these petitioners, my lord, they had acquired eligibility for promotion to the cadre of sub-inspector. The earliest is petitioner for Satyaji Sabha Pandit. He became eligible in 2003 itself. In the case of others, 2006, 2005, 2004, 2011. The last is 2011. As early as 2003, my lord, petitioner for Satyaji Sabha Pandit became eligible. And my lord, so far as holding of DPC is concerned, also I have shown by the way of chart, in 2006 itself, the first DPC in this decade, my lord, it was held in 2006. 2007, no DPC, 5 vacancies were there. 2008, again, there was no DPC, there were carried forward of 5 vacancies. 2010, 14 vacancies, because 9 more vacancies arose. 2009, 14, 2010, 14. So from 2006 to 2012, there was no DPC whatsoever. In 2006, when the DPC was held, thereafter, below, the next DPC was held only in 2012. And the 14 vacancies straight away were accumulated. In 2006, my lord, the 5 vacancies were carried forward. And those 5 vacancies were there in 2007, 2008, and in 2009, 9 more vacancies came, making it 14 vacancies. They did not hold DPC at all. And had DPC been held, my lord, in 2009, in 2010, 2011, please, my lord, some of us could be easily promoted. Had it been in 2011, all of them would have been promoted. All of them. We would have been much senior to direct recruit. They do nothing about it. So May 2011, my lord, they initiate the process. The dates, my lord, will see. Delay. May 2011, they initiate process under Rule 11, Sub-Rule 2. Then next date is 20th of January 2012. Government of Assam issues a notification constituting a selection committee to hold its meeting on 14th February 2012. Then 7 months, nothing happens. 14th February 2012, selection committee meeting is not held. Next date is 1st August. Since meeting of selection committee could not be held on 14th February 2012, Director Food and Civil Supplies and Consumer Affairs wrote a letter to Deputy Secretary Government of Assam, Department of Food and Civil Supplies and Consumer Affairs, asking about the date and time for next meeting of selection committee. Then again, 12-10, and what you will see the time gap, substantial. 20th January 2012 to 1/8/2012, nothing happens. Then 12-10. Director Food and Civil Supplies Consumer Affairs wrote a letter to concerned officer which reveals it was decided to hold the meeting of selection committee on 18-10, but on that date meeting was not held. So they are delaying the holding of the meeting itself. Finally, 21-12-2012, WT message was issued containing the names of all the eligible candidates under the zone of consideration for promotion to the post of Sub-Inspector Food and Civil Supplies. It was decided to hold the meeting of selection committee on 26-12. Finally, my lord, meeting is held on 26-12. Meeting is held on 26-12, but the recommendation of DPC is acted upon on 18th June 2013. And orders were issued on 20th June 2013. And finally, we joined. So, Lordship will see the entire sequence of events from May 2011. And on top of it, prior to May 2011, from 2007, 2008, 2009, 2010, 2011, for 5 years, no DPC. And vacancies were accumulated in the promotion quota. So, my lord, fault lies entirely on the state. And lastly, my lord, I will just show the residuary power of the state. If they say, oh, there is no power, 32(6) is there, my lord will find in the rule itself, 41. Sorry. Page 33. Internal page 33 of the paper book, Rule 34. That is the government power of relaxation. Power of government to dispense with or relax any rule. Where the government is satisfied that the operation of any of these rules may cause undue hardship, any particular case, it may dispense with or relax the requirement of that rule to such extent and subject to such condition as it may consider necessary for dealing with the case in a fair and equitable manner, provided that the case of any person shall not be dealt with in any manner less favorable to him than provided in any of the rules. The power of relaxation is there. They could have, my lord, they could have relaxed the mandate of 32 sub-rule 6 because of the facts. They could have said nothing doing. Even though we have appointed you in 2013, your seniority will rank above Abdul Kalam Azad at serial number 3. You will be treated to be the recruit of 2012, and accordingly, you will get your seniority over the direct recruit. They could have said that. And that would satisfy us. We want no other benefit. The only thing we are seeking is a seniority fixation above the private respondent, namely the private respondent number 4. He is the person, main person. If all of us get our seniority over the private respondent 4, purpose is served. We don't want any other benefit. So, my lord, in the facts of the present case, our seniority may be fixed, showing us to be the appointee of 2012, getting our seniority over respondent 4. That's my prayer. Lordship may consider.
Yes, CKS.
The affidavit we have filed is very short, Lordship. First thing is that, Lordship, in our paragraph number 9, the Departmental Promotion Committee for the selection and promotion of eligible candidate for ministerial staff seeks to fill up the vacancy aroused against the earmark 25% sanction post in the cadre of Sub-Inspector of Food and Civil Supplies. The DPC was conveyed on 2006 and 2012 because vacancy position arose only during this year's, Lordship. Secondly, Lordship, that 75% of the post of sub-inspector of food and civil supplies consumer department are filled up to direct recruitment, and 25% of the post of sub-inspector are filled up by promotion for ministerial cadet from director of food and civil. So that's what is say rule 32 says, Lordship. Then after that, Lordship, we have stated that appointments were made under direct recruitment for 145 number of posts of sub-inspector on 19/6/2012, which we have stated. On the other hand, appointments were made for promotees under promotional quota on 29/6/2013. Therefore, Rule 32(6) of the Assam Food and Civil does not arise, Lordship. This is the this is
When was the promotion made? Promotion?
Promotion Lordship 29/6/2013.
Yes.
And direct recruitment on 19/6/2012, Lordship.
Yes.
Now, as per the second thing is that, Lordship, the last annexer of his writ petition, that all these persons have given the objection, these objections will be rejected by the authority also. That is a, Lordship, it wishes to see page number, Lordship, page number 129 to 137, Lordship. May I just read out, Lordship? Whereas a provisional gradation list
120.
is basically annexer 14, page number 129B of his writ petition, Lordship. That is the order, Lordship. Basis on the objection provided by them. Whereas a provisional gradation list of 133 number of sub-inspector of food, civil and consumer affairs department appointed under 11(1) and Rule 11(2) of Assam Food and Civil Supply Services of 1970, as amended after 2000, was published and circulated amongst all concerned by this director letter, so inviting claims and objection thereof, any latest by 2017. And whereas the aforesaid provisional gradation list was a combined list of sub-inspectors recruited directly to the post of sub-inspector and promoted to the post of sub-inspectors from amongst the ministerial quota, out of 132 number of enlisted sub-inspectors, 170 number of sub-inspectors are direct recruitees, 14 number of sub-inspectors are recruited by promotion from amongst ministerial quota, and 1 number of sub-inspector is recruited on the ground of extremist violence. There are certain claims and objections in regard to fixation of inter-se seniority in service among these 132 numbers of sub-inspectors, which are disposed through speaking orders after conducting necessary hearing. Meanwhile, 2 number of sub-inspector, namely Sri Rupam Dibragade, serial number 3 in provision.
That they have been promoted.
Yes, I have been promoted. Therefore, considering all the above circumstances and the exercise of the powers conferred by surplus 5 and 6 of Rule 32 of Assam Food and Civil Supplies rules, see Deepak Chaudhary, want to objective. Deepak Chaudhary, ACS Civil Supply and appointing after do hereby publish the final gradation list as many as 130 number of existing sub-inspector of food and civil service affairs, fixing the inter-se seniority in service. The orders have. Secondly, Lordship, in regard to the EPC, Lordship, that he has stated that that we have clubbed all the promotees and of all this, because each and every all these years.
Let me have a copy of that guideline with regard to
that guideline today, Lordship, I doesn't have. In our attached with our affidavit in operation, that I have to make on what basis they have clubbed all these years, promotion of all these years. I think that's it. Rule 32 of it. That guideline we have to get. On what basis the departmental promotion had clubbed all these promotion and appointed in one list, and after that it was been finalized.
And the guideline with regard to holding of DPC?
That's what, Lordship, because the DPC, it has clubbed, Lordship, like.
No, that is a different thing. That records will speak. Records will speak.
That's what, Lordship.
Records will speak, but the guidelines of holding DPC,
these are two, one is record, one is guardianship. So both we have to get lordship. The record is not with me right now, and guardianship I have lordship sitting. So I have to.
Okay. Heard Mr. P.K. Devan, senior counsel, assisted by Mr.
A.R. Gogoi.
A.R. Gogol and the counsel for the petitioner. Also heard Mr. C.K.'s
But my brothers have also something to say. Also, he may also be heard.
Parole, the government advocate for respondents, 1 and 2.
1 and 2, lordship.
And Mr. M. Sharma, the counsel for the respondents.
4, 5, 5, and 8.
And 8. Yes. No, I'll hear you on the other day.
Yes. In fact, your lordship, just a small submission here. Will make my submission later also. The selection committee and the appointing authorities in the rules, they're clearly earmarked. The appointing authority is the authority who is going to appoint the recruitees as well as promote under Rule 11. The selection committee sat on 26/12/2021 and they recommended the name of the petitioners for promotion. There is a submission, your lordship, made in the writ petition that states that recommendation had also had to receive the concurrence of the WPT and BC department and the finance department. Now, 26th of December was a Wednesday. And these are the facts of the matter.
No, that.
Yes,
that
yes,
part-
again, your lordship will look into it. I'll make my submissions on the date.
I'll look into the matter after the Mr. C.K.'s Baro.
Yes.
The government advocate shall produce the records.
Yes.
As well as the guidelines with regards to appointing of DPs of matter in the state of Assam. Holding of with regard to the government of Assam. Not state of. When?
I'll leave it to your lordship in my senior's convenience.
No, lordship, it will not take much time because the thing only has to come from the department. Minimum 3 weeks. I can.
Wow.
Minimum. No, okay. 6 weeks.
It won't take much time.
No, because only one, perhaps, no, 15 also. Okay, the lordship, before this, in the first week of April, lordship.
No, could it be on 25th March? 25th March is sufficient time.
25th March is a holiday.
It's a holiday.
Oh, sorry.
27th. Not 28.
That's important.
29th, let it be.
29th is also a holiday.
I included your lordship will kindly hear me also for the client.
No.
Yes. I'm grateful, your lordship.
Certain files, my lord.
Where is the petitioner? in
He is
person?
here, my lord. Can it be taken up on some other day? I need some time to reconstruct, my lord. My
Lordship,
own
there
affidavit is
there is a
missing.
court order in 8th of January that respondent number 2 supposed to submit the departmental document, but they are yet not submitted any document. In court order 8th of January.
I think, my lord, there was an order to produce the records of the departmental proceeding.
1 minute.
If any records are
8th
there.
of January.
Yes,
2024.
Yes, attention.
Yeah, departmental record.
Well, that also I'll procurement.
Okay.
Lordship, I have also prepared a document. So I will submit it before the next day.
But Mr. Abhinash Bora.
Yes, Lordship.
Petitioner in person. On request made by Mr.
N. Deca, my lord.
N. Deca, Learned Counsel.
2 and 3.
For the respondents, 2 and 3. List the matter after?
2 weeks, my lord.
After 2 weeks?
Lordship, can I get the document before the next day?
Records, my lord, he will
No,
give-
that records you will not be given to you. It will be produced
it will
before
be
the
produced
court.
before the court.
On request made by Mr. N. Deca, Learned Counsel for the respondents, 2 and 3. List the matter after 2 weeks to enable him to produce the records.
Lordship, grateful if the fixed can be provided.
Okay.
A fixed.
List the matter on. When do you want? After Bihu?
Maybe after Bihu, my lord.
23rd
23rd
April.
23rd. No, my learned friend appears for 4, 5 and 6, my lord.
4, 5, and 6. HK Das, Learned Counsel appears for respondent number 4, 5, and 6. 4, 5, and 6.
4, 5.
Okay.
List the matter on 24th. That's all. I've already said that. So have you taken it?
11, hearing.
May it please Sir Rosid, my lord. My lord may recollect that matter, my lord, once this writ petition was dismissed, and then in appeal, my lord, the appeal was allowed, my lord, holding that there was procedural irregularity in the inquiry, my lord. That order, and before that, my lord, lordship on last occasion 22/2/2024, my lord, there's an order that if the petitioner can get any medical certificate from the doctor with whom he was under treatment, my lord, lordship given that opportunity to the petitioner. And pursuant to that, he filed one affidavit, my lord, on 5/3/2024, my lord.
Why was the matter adjourned last occasion?
To give him an opportunity to bring anything if he has on record.
Medical report.
Yes, my lord. My lord, he could find out the doctor under whom he was under treatment, my lord. Page 145 of the additional affidavit filed
This is
on.
of February 2024.
That's correct, my lord. Kindly see the language, my lord. Language, my lord. This is to certify that Pankaj Bezborua is a 32 years, son of Sri Ajit Bezborua, resident of village Pub Soriatoli, Hati Naumati, district Nolbari, was under my treatment for the period 16/10/2010 to 29/6/2010. That's right. 16/9. 11, my lord, sorry, 29/6/2011 and 22/7/2011 to 24/10/2011 for the disease suffering from his head injury and external hematoma right temporal region. My lord, and moreover, my lord, I will be very brief, my lord, because I have made my submissions on earlier occasion, my lord. In the writ appeal, my lord, writ appeal 164, lordship, on earlier way I placed that order, my lord. 164/2022. This is judgment of 27/4/2023, my lord. My lord, 164/2022. Pankaj Bezborua. This is the order person appeal, my lord.
Yes.
My lord. My lord, para 3, my lord. This is the SARS the honorable court has, my lord, quoted, my lord.
Yes.
And here is the, my lord, period is 347 days. Now, my lord, para 6, my lord. Learned counsel representing the appellant urged the specific argument was advanced before the learned single judge that neither the article of charges stated that absence of the appellant from duty was willful, nor did the inquiry officer conclude so against the appellant. He further submits that even the disciplinary authority, while passing the order of dismissal from service, did not hold appellant responsible for willful absence from duty. Moreover, the disciplinary authority did not record any specific finding as to whether the appellant herein was responsible for more heinous offense as defined under Section 9 of Central Reserve Police Force 1949. Less heinous offense as defined under Section 10 of the said Act. Thus, it was a fervent contention of the appellant's counsel based on the Honorable Supreme Court judgment in the case of Hussain B. Parmar versus Union of India, reported in 2000 so and so, my lord, decided on that the penalty of dismissal from service imposed upon the appellant was totally unwarranted, undue, has disproportionate and unjustified. He does implore the court to accept the appeal, reverse the impugned judgment and order passed by a single judge, and was the same as a consequence, possibly reverse the order imposing penalty of dismissal of service upon the appellant. Par contra, my lord, this is submission of the respondent side, my lord. Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, vehemently and fervently opposed the submission advanced by the appellant counsel he argues that no such argument was ever advanced on behalf of the appellant before the learned single judge, that impugned proceedings suffered from any procedural defect or irregularity. His assertion was that even the argument on lack of finding regarding allegation of willful absence from duty was not advanced on behalf of the appellant before the learned single judge. This is the argument, my lord. Now, my lord, he submitted. Because, my lord, para 9 is very important of this judgment, my lord. Para 9, the honorable court has held, found that my pleadings were there in the writ petition. So therefore, without proving as to whether my the inquiry officer failed to prove that as per Kusan B. Parma's judgment, my offense must be held to be willful, my lord. And therefore, the honorable court, para 9, my lord, of this judgment, para 9, at the outset, we may note that there is inherent lack of phraseology willful absence, my lord, in the article of surgery as well as order imposing penalty. The pertinent ground spelled out from the pleadings of the representative that there is no allegation against the appellant representative of being willful absence from duty. In this regard, we would like to refer the averments made in paragraph 17 of the writ petition. My specific ground is there, my lord. My lord, that the argument was that I have not taken this ground whether this inquiry officer is like to be proved my absence was willful or not. But my pleadings were there, and therefore the honorable next page, my lord, page 7. And therefore, my lord, challenge the dismissal order on the ground of procedural irregularity, my lord. The honorable court, my lord, came to a finding there was a procedural irregularity, having not said by the inquiry officer that absence was willful. That has to be a definite, my lord, finding to that. In this connection, my lord, by concluding this way, my lord, procedural irregularity of the inquiry, however, the matter was remanded back. Therefore, this matter before lordship. Now, my lord, my submission is that, my lord, I have also placed that judgment Kusan B. Parma, 2012 TSCC 178. There are only 3 paragraphs. My lord, 17, 18, and 19, my lord. If the absence is the result of compelling circumstances under which lordship found, my lord, 2012, my lord, TSCC 178, paragraph 17, 18, and 19, my lord. Here, broadly, the Honorable Supreme Court said, my lord, all unauthorized absence will not amount to willful. In a case of willful absence, my lord, the unauthorized absence must be willful, and that has to be proved in the inquiry. My lord, para 17, if the absence is the result of compelling circumstances under which it was not possible to report or perform duties, such absence cannot be held to be willful. Absence from duty without application of prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which the employee abstained from duty, including compelling circumstances beyond his control, like illness, accident, hospital, etc. But in such cases, employee cannot be held guilty of failure of deviation on duty behavior of becoming of the government servant. In a departmental proceeding, if allegation of unauthorized absence from duty is made, my lord, the disciplinary authority is required to prove that the absence is willful. My lord, here is no such conclusion. Lordship, just for a moment, inquiry report, my lord. Inquiry report, my lord. Inquiry report at page 37. This was forwarded by page 36, 19, Annex 11. Now, my lord, yes, page 38, my lord, directly the analysis of evidence, my lord, as to why I was absent, my lord, page para 6, my lord, page 38. my lord, from the third line, whereas on the basis of the statement of Constable Pankaj, it is learned that as he did not know anything as to what had happened to him due to his illness, mental stress, my lord. My lord, I am showing this because there was some reason behind that actually, my lord, here he made an accident. And after that grievous injury received, for that which and he was under treatment, his parents brought him back from Delhi, my lord. And moreover, now page 39, second paragraph, my lord, from the bottom, my lord. Other witness, what they say, my lord, about my absence, my lord. On the basis of witness number 1, 2, and 3, Constable Pankaj Besbura found to be obedient to his duty, but no information could be found as to why he absconded. As per version of the accused, he absconded and remained absent owing to his mental stress or illness. No, reason was there. They could have forwarded at this moment this particular person, writ petitioner, before the medical authority, whether he was suffering or not. They have not done anything. Moreover, the conclusion, kindly see, my lord, what is required to be drawn as per this judgment, my lord, page 40, suggestion of the inquiry officer, my lord. From the statement of accused and the documents submitted in connection with the search level against so-and-so Pankaj Besbura, as the accused appeared before IO after he had been served notice by the IO, but again absconded before completion of investigation, it seems that Constable Pankaj Besbura does not want to rejoin in the force. Therefore, on the basis of statement and evidence, the investigation will come to conclusion that the allegation level against force number so-and-so established. But whether my absence was willful, and this was not even a statement in the allegation, statement of allegation, my lord. Statement of allegation, page 31. That they said, no more got to page 31, my lord. Article SARS, my lord, that the so-and-so Pankaj Besbura, while functioning as Constable General Duty GD, my lord, Mahabir Nagar campus, New Delhi, has committed an act of misconduct in his capacity as a member of the force under section 11(1) CRPF, unauthorized absence, my lord, that he deserted from the colony line on 14/10/2010, was 17 hours and still absconding without any information or any prior permission to the competent authority, which is prejudicial to the good order and discipline. My lord, even the search is not whether his unauthorized absence willful. An inquiry officer has also not concluded to that effect. Therefore, my lord, honorable division bench in this case, my lord, held that there is procedural irregularity in the inquiry, my lord. My lord, lordship will find the total breakup of my unauthorized absence at page 48. Page 48, para 6, my lord. $347 days. And para 5 in the middle, my lord, lordship will find, this is very important. Para 5, my lord, he reported back at his own on 1/7/2011. And
where is it?
Yes, my lord. Para 5, my lord, middle line, my lord. Delinquent so-and-so, Pankaj Besbura, CRPF, my lord, deserted from lines under 14/10/2010, about 17 hours, and he reported back at his own on 1/7/2011.
Page 48.
Yes, my lord. Para 5, my lord, middle portion, my lord. He reported back at his own on 1/7/2011 and again deserted from line on 19/7/2011. My lord, this is the period, my lord, I have given the certificate, my lord, for your lordship's satisfaction. Now, my lord,
1 minute.
my
Yes.
My lord, after that, my lord, dismissal order, he submitted the appeal, my lord. Appeal, there was, I admit, my lord, there was some delay. I have explained as to why there was a delay in the, my lord, appeal, my lord. In page 52 is my appeal. 21/1/2017, this is the appeal, my lord. Against the, my lord, dismissal order, page 52, my lord. And paragraph 9 of the appeal, my lord, I have mentioned why this was delayed, my lord. Paragraph 9, my lord. And now the, my lord, authority kindly see, my lord. Order passed by in appeal, my lord, page 64. Nine 5/2017, my lord. Page 64. My lord, here one important aspect, my lord,
1 minute.
my
Yes.
my lord. Yes, 65, my lord.
65.
Yes, page 65. 3, 4, 5, 6. The first para, my lord, 6 line, my lord. Father, his mother, from the middle, my lord. After the underline 4 lines, my lord. Father, his mother, Srimati Ira Besbarua, had submitted application dated 10/11/2011 that due to mental disorder, her son Pankaj Besbarua could not attend his duty for long. Now Pankaj Besbarua under treatment LGB, Regional Institute Mental Health, Tezpur. In reply,
So you're taking your treatment in this particular hospital, isn't it?
yes, my lord.
But your medical certificate is given by somebody else.
No, my lord, that after this period, my lord.
No, no.
No, yes.
It's for this period.
No, my lord. Also kindly have a look.
You check up your medical certificate.
Yes. Medical certificate in LGB, my lord, page 27, my lord. In Tezpur, my lord.
Page?
Page 27, lord. Sir. Page 27, my lord. This is the certificate issued by Tezpur Medical Mental Health Institute, my lord. 28/10/2011 to 7/11/2011. My lord, while he went to this Tezpur, my lord, in the meantime that impugn order of dismissal from service was already issued, my lord, 12th October 2011. And prior to this period, my lord, I have stated in the petition that after he met with the accident, my lord, yes, and this certificate, my lord, before this period. My lord, this is my case, my lord. In view of the decision of the division bench, my lord, honorable division bench, my lord, wherein the honorable court has held that there is procedure
That part
irregularity.
is okay.
Yes,
That
ma'am.
part is okay.
Yes.
I'm talking about your medical treatment.
Yes.
You have not been able to prove. That's the basic thing. We adjourned this matter last occasion.
Yes. Now,
So
my
you
lord,
come to page 62.
yes. My lord.
So this is a receipt.
Yes. My lord. My lord.
This is a receipt dated.
28/10/2011, my lord.
So that time also you were under treatment under LGB.
Yes.
But your medical certificate, Ariana Medical, this is somewhere else.
My lord.
145 of
Yes,
your
ma'am.
affidavit.
Because, my lord, this is after this certificate, my lord, because for this period, 16/10/2010, my lord, to 29/6/2011, my lord, his parents brought him from Delhi, my lord, and given treatment at Nolbari. Lordship, kindly recollect, my lord, last occasion, even I, in the paragraph also, I have stated in my pleadings, my lord, and therefore Lordship has directed the whether or suggested whether he could get any from Nolbari.
Okay.
So for the period this he was in Nolbari, my lord, his parents brought him back to Nolbari at their native land. And after this also, while he was not, my lord, recovered, then he was for the after this period, my lord, he was admitted at Tezpur mental health. However, on evaluation, no psychiatric illness was found. Now, my lord, that they have not found psychiatric any illness. However, since he shown some character of psychiatric patient, therefore he was admitted there for this period. And prior to this period, my lord, in my humble submission, my lord, this doctor has certified he was under his treatment, my lord. And moreover, my lord, in a case of unauthorized absence, standard of proof as per judgment of Kusanbi Parmar, my lord, what has been upheld by the honorable division bench, my lord, I raised other the matter of lawsuit, because honorable division bench has already said procedure regularity, and against that they have not made any challenge to that matter.
Yes.
Obliged.
Worship, my friend's case is based upon few paragraphs of Kushanbi. If we may look into paragraph 18 once again. 17, 18, I'll just read out two paragraphs. If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. If it was under compelling circumstances. 18.
1 minute. Give me a stapler. Yes.
Paragraph 17, Lordship, it starts with, if the absence is a result of compelling circumstances, under which it was not possible to report or perform duty, such absence cannot be held to be willful. Lordship will just mark the words absence is the result of compelling circumstances. Now, he has to show the compelling circumstances. Next paragraph. Absence from duty without application or prior permission may amount to unauthorized absence, but does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances. Now, both are related to compelling circumstances. If he can show that there were compelling circumstances, I could not come. That is the ratio by and large. Now, Lordship will see when he met with an accident. He met with an accident on 22/12/2009. That is he saying. I do not say that he has met with an accident, Lordship. I would not subscribe to that view. It is only a statement made by him. And I would further say, it is a statement made by him only to make out a case. Because if he has suffered a head injury, Lordship, he is a CRPF personnel, he will get free treatment in the CRPF hospital. Let us say he did not opt for the CRPF hospital. He must have gone to some hospital. There is nothing, Lordship. Now a certificate given by a medical and health officer. He is a medical and health officer in 2024. Lordship will just make a mark. And he gives a certificate pertaining to a period of 2010. Was he a medical and health officer at that point of time, Lordship?
That's what I was asking you.
And he was there. He has given,
Now,
he
Lordship,
was under my treatment. This
Lordship,
is the language.
That we know.
Yes.
Lordship,
Because backdated cannot.
I'm on that
Yes.
line.
Yes.
In 2011,
Mal.
correct, when he was giving a treatment. Was it?
Yes, yes.
Are you sure?
Yes, my lord, it was confirmed, my lord, yes. This
How-
doctor was in the pharmacy, my lord, yes.
Was indeed?
Was in the Aranya Medical, Aranya Medical is a private pharmacy, my lord. And presently he is working in SMK Mukundo Kakoti Hospital, Nolbari.
No, in 2011,
Yes.
was he the medical and health officer? That's what we are asking you.
My lord.
Because by production of different medical certificates,
my lord.
you're getting yourself into more trouble.
My lord. My lord, so
Was
far,
this
I,
person-
my lord,
Was this person Pankaj Bes Barua?
my lord.
Was the health and medical and health officer in 2011?
Gautam Nath, Dr. Gautam Nath.
Is it Dr. Gautam? Yeah, sorry.
Yes, yes.
Dr. Gautam Nath. Was he the?
No, my lord,
medical
my
and health
instruction is that, my lord, this Pankaj Besbarua under his treatment in privately and Aranya Medical, my lord. Not in the, my lord, as a health and medical officer, my lord.
he cannot put his seal, Lordship.
Then how can he put-
My lord.
If that is his contention, he cannot put his seal.
And this is my submission, my lord, because I have been, my lord, instructed that as a private patient, my lord, outdoor patient in Aranya Medical, is a pharmacy, my lord, clinic, my lord, there he used to, my lord, treatment. Not in the, my lord, as,
Was this doctor there in that Aranya Medical?
yes, yes.
In
yes,
2011?
Yes, yes, that is.
How do we know that? How do we know that? That's what I was asking you from.
Otherwise, he was
See,
there,
basically, you have a good case.
my lord.
You have a good case.
My lord.
If we, but the thing is, your medical certificate is
Yes.
pulling you down.
My lord.
You don't have any documents to indicate that for this period I was having a medical treatment and so and so, so and so.
My lord.
For so and so period, I was under medical
My lord.
treatment. You don't have any documents.
My lord. He lost.
Now
the-
suddenly you file this additional affidavit
My lord.
in giving a certificate in the month of February 2024,
My lord.
saying that you were under treatment, under his treatment in 2011. Was he the doctor available at that period of time?
In the, my lord, Orendo Medical Pharmacy, he was there, my lord.
How do you know that?
And I am not saying the hospital, my lord.
Just give us that clinching issue, raises your
Yes.
case is allowed.
Yes. My lord.
But without that document,
My lord.
without that clarification, you don't have a case again.
My lord.
So what do
Yes,
you want to do?
correct. My lord, moreover, my lord, if they can,
If he has
if my lord, this is the certificate, they may have one is inspection, my lord.
why we should
Whether
know?
this
Why
doctor
they should
was,
do it? You always is the onus is
Yes.
on you.
my lord.
And lordship, second,
And,
if we leave about the medical certificate.
yes, yes.
He has suffered a head injury. If he has suffered a head injury, which he says is a result of an accident, and for that he was mentally imbalanced, where are the investigations? He cannot say, I suffered a head injury. Lordship, every day we knock against something. That cannot be a head injury, Lordship. If he says that I suffered a head injury and for that I lost my mental balance, that has to be pretty serious. There is nothing. And Lordship will note. He says that after getting well, I attended the inquiry. He attended the inquiry again, he absconded, Lordship. We cannot overlook that. We cannot overlook that. And so far as his treatment in the mental hospital in Tejpur is concerned, he was a outdoor patient. There is a ticket of outdoor patient. He got himself admitted as an indoor patient for around 7 days, and he was discharged at his own request.
That I've taken note of.
At his own request. A sane person will not. That is,
He's not at his own request, but he got himself released.
yes.
That is the language
That-
used.
that is, Lordship, now, at that point of time, nothing peculiar was noticed so far as his psychiatric problem or mental problem is concerned. Now he cannot harp on something.
No,
Doctor did not find anything, but I am so and so. He cannot say that. That is up to the medical practitioner.
Mr. Das,
My lord.
I'll give you one more opportunity.
My lord.
I'll give you one more. Prejudicing the case of the respondents.
My lord.
I'll give you one more. You bring some medical certificates, some investigation reports
No.
showing that I was in the treatment for so and so, so and so, so and so. I'll give you one more opportunity.
But,
Do you want to take that opportunity or want to get the minute disposed of today?
my lord, because, my lord, if he tries to get and this doctor, what they write, my lord, this would lead, my lord, it will go against him, my lord. I know, my lord. My lord, therefore, my lord, my limited submission. Lordship, kindly consider my limited submission on even if
At least try to show that this particular doctor was in our, what is it?
Arena.
Arena hospital.
Yes.
That pass even at that.
No. He
He may not have passed.
No.
MBBS at that point.
2011, 2024, this is quite a long gap.
My lord, therefore, my lord, his designation, my lord, he get promotion, my lord. Medical Health Officer 1. He was there. This is not a doubt on this, my lord. He can have a, my lord, a prospect of this, my lord. And moreover, my submission, my lord, I may not be able to get any more certificate or prescription because in my petition, para 4, I have stated, while in journey to join on 1/7/2011, when that for a particular period he was in the inquiry, 1/9/2011 to 17/9/2011. And in this journey, he lost everything while going to Delhi. Now here is the case, my lord.
But you have some more documents. You have
Yes.
some documents.
Yes.
If you have lost everything, then these documents also should not be there.
Yes.
No, my lord, it is through RTI.
No, not
through
RTI. Not RTI. These are your medical certificates.
This one, my lord, he has found a doctor and he requested, my lord. I also instructed if you get the doctor, So far, so far, my lord, kindly have a look, my lord.
That
Page
is the
24, page 24, my lord.
I
This,
know.
this certificate from, Tezpur Mental Health, my lord, page 24, through RTI, my lord, he got it. After losing everything, because this certificate was forwarded by his mother while the appeal was pending. They were supposed to consider this application, the mother's application. They have not considered. To RTI, my lord, 2016, he got, my lord.
But that does not help you.
And moreover,
Finding.
my lord,
Because his health is otherwise.
I will be, my lord, now placing my case only on the ground, my lord, whether lordship may consider my case on the basis that inquiry officer lacking, because honorable, this was the argument before the division, honorable division bench. The division bench said no, learned single just cannot be step into as an inquiry officer. This was the, my lord, word mark during the course of hearing.
That I don't know.
Yes.
I have not heard.
But
He says I have.
But my lord, so far, my lord, so far, the procedural illegality that is there, my lord, they have not gone in appeal or against that order, my lord. That remains. Whether lordship can, my lord, look into that, my lord, on that basis, the procedure, if there is procedural irregularity as marked or observed by the honorable division bench, my lord, in that case, my lord, because other two cases, Thermesa Seal, my lord, one matter, lordship has decided that matter. This is the same issue. A 414 days delay, my lord. He unauthorized absence. That lordship's judgment, my lord, WPC 2799 2017, my lord. My lord, WPC 2799 2017. I last occasion I placed, my lord. If required to, I will place.
Yes.
WPC 2799 2017. Now, my lord, paragraph was 7, my lord. Last paragraph. 414 days delay. His lordship, my lord, by referring to this judgment of Kusan B. Parmar, para 14. Para 14, my lord. Lordship has referred this to his paragraph. Para 18, 14, subpara 18, my lord, from the judgment, in a departmental proceeding, if allegation of unauthorized absence from duty is made, discipline is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. In the present case, the inquiry officer on application of evidence to held that the appellant was unauthorized absence from duty, but failed to hold that the absence was willful. The disciplinary authority also will have failed to appreciate the same and wrongly held that the appellant guilty. And this is the squarely covered case, my lord. And lordship has given the relief to the petitioner. Against this, my lord, they have preferred appeal against this judgment. The Union of India, my lord. Very interesting, lordship. Appeal, writ appeal. Yes. Writ appeal number 52 of 2019, my lord. My lord. My lord, while admitting the appeal, lordship's entire judgment was not stayed. Only whether this 50% backwards is entitled or not. He was directed, the respondent was directed to reinstate in service. However, the appeal was admitted so far as the 50% is justified or not, backwards. After that, my lord, the honorable division bench, by the judgment, upheld granting of 50% backwards, my lord, while upholding the order passed by this honorable court.
Lordship, we are not on that way.
No, that is different. While this is the same case because unauthorized absence.
That's not this case, Lordship.
Same case.
Here, Lordship, will see the.
Here, 414 days delay. Here.
It's not the delay. Lordship,
No,
it's the
not
article
delay.
of charge.
Unauthorized absence.
See, Das.
My lord.
All these writ petitions, this Dharmeshwar seal, the appeal which went.
Yes.
Appeal was with regard to 50%. That's the difference.
That
Dharmeshwar seal also there was proper medical certificate.
was there.
Paragraph 7, you did it. Everything was. Here, we are trying to help you out. We are trying to help you out. Why can't you help yourselves?
Yeah,
Why can't you find something? That's what I'm saying. We are trying to help you out. Why don't you help yourselves also? You just can't keep on sitting and say, help me, help me. You have to help yourselves to get help. May not be proper in front of Mr. Chowdhury saying all these things.
No, Lordship, if he can, Lordship, that is another aspect of, but
That's
based
what
on
I
the
want.
material, Lordship, there is no.
Why not? I'll give you 2 weeks time. Try to get some.
I will try, my lord. I cannot assure this, my lord.
Oh, you can't assure this.
Yes.
I'm not, this
Yes,
code
yes.
is not telling you
Suggestive, my lord, yes.
to manufacture.
No, no, never, never.
This code is just trying to say that if you can find something, do it. If
For
you
the
can't-
satisfaction of the
if
at
you
least the
can't, then
honorable.
let's see what we can do. But BK does then a counsel for petition. Also heard Mr. R.K.D. Chowdhury, London Deputy Solicitor General of India, for respondents. Please the matter for further hearing. When do you want? Last chance.
My last answer. As per lordship's convenience,
No, no,
because
you give your date.
but
Oh,
on my lord, 30th April, my lord.
on 30th. As what? You try your luck.
Obliged. Thank you.
14.
My please, lordship. This is also dismissal of service, lordship. On the ground of unauthorized absence and additional allegation is a forgery, lordship. Lordship, the enquiry held under section 27, level 27
of
CRPF rules. Central Reserve
Let us
Police
have
Force.
the CRPF rules.
But we were not furnished with the inquiry reports and other, even dismissal order also. The whatever was furnished, we have annexed with the petition, by which it has been communicated that for overstaying in house for 52 days, committing forgery in warrant, we have been dismissed for service. And by the same order, it is also communicated that some period of overstaying has been regularized. Now, they have filed affidavit in opposition, lordship, and along with the affidavit in opposition, they also annexed the detailed, this is the dismissal order by the commandant.
Is the dismissal order under challenge?
No, lordship, we preferred an appeal. Initially, first we preferred the appeal before the DIG Shillong. Then we have been communicated that proper forum is DIG Silchar. Their appeal has been filed there also. Then no decision was taken. Then we made an application to proceed with the appeal, but no response. Then we preferred this petition. Now it has been many years, but against the affidavit in opposition, we unfortunately did not file any reply, which was required, because these dismissal order they have annexed, it shows that there is a procedural irregularity in holding the inquiry. Inquiry report was not communicated to us, so that procedure also not followed. We are not given opportunity to submit written statement against this inquiry report.
1 minute.
And
You've been removed from service.
dismissal.
By which order?
By, they have annexed with the affidavit in opposition, see page 79. This is the detailed order. We did not get
Page
79.
79 is not there.
I think affidavit in opposition. Yes. They are affidavit in opposition. Annexed at 7. They have made 7. 79 order. Sorry, it will be 19 lordship. They are page 19 of affidavit in opposition.
Page 19.
19 of affidavit in opposition.
Affidavit in opposition filed on behalf of respondents 2, 3, and 4.
2, 3, 4, and 5.
Page
19. Like 7.
don't have page 19.
Translated copy of this. 19. 19.
Yes. 2015.
Yes,
This one.
2015 lordship.
By this you have been removed.
Removed.
This order under challenge.
Against this, appeal was filed.
Maybe a bill was. This order under challenge.
Yes, for setting aside.
It is not
lordship.
challenged.
2 to 5, yes. But this order was not furnished to us. So
No,
we did not know, but this order dated, our prayer is lordship.
Where is your prayer?
Setting aside, implement order is 2. Page 9. This order is not under challenge, lordship.
Then what?
Because
can
it
you
was
do?
not furnished to us.
At least it is finished through the affidavit in opposition.
Yes, lordship, we could not file this. This is our
Then
lapse. We did not. file it.
nothing more remains in the writ petition. The main order is not under challenge. Then what can we do? When they ordered removing you from the house, you have left it aside. Then what more how do you get inside the house?
If we can amend it, if we can amend it now. Because by the order dated, this petition 4 to 2015, we have been communicated.
That's fine. That's
And
fine.
that was under challenge.
That 4 to 2015 is something else.
Yes, yes.
That is page 34, isn't it, of your writ petition?
Yes, 34, 36.
34 of your writ petition.
Yes.
It says that you were terminated, you were removed from service by the order dated 2 to
2 to 2015.
2015. That has not been challenged.
That is not been challenged.
What do you want? What more do you want? Nor have you filed a reply.
If your lordship may I pray for an opportunity to file a reply to this.
No, filing a reply, how will you challenge that order?
Otherwise, by your amendment also we can. Otherwise, there is a procedural delay apparent from this order.
Whatever it is. It's a choice you have to take.
So I pray for an opportunity, lordship.
What do you want?
I will file an application amendment, lordship, incorporating this.
Amendment of what?
Writ petition, lordship.
That would change the whole complexion of the writ petition, isn't it?
No, on the basis of this affidavit of opposition, we will just challenge this one only.
Then they will require time to file the affidavit in opposition. It's your choice.
Two weeks time, lordship, we will file it. Then they will get opportunity, not because it is also their case that this by this order we have been dismissed. Earlier, although it was indicated in this order, but
When was the affidavit in opposition filed?
it was in 2018, Lordship. It has
18,
been
my lord.
6 years.
18,518.
What is left?
Huh?
18,518.
How can you commit this type of mistakes also?
This sum of missed sectors.
Client is
Nah,
depending on you.
He was removed from service, my lord, on 2nd February
That
2015.
we have seen.
Long day.
He is challenging the order dated
4-2.
page 34 of your writ petition. Even if you challenge that order, this order of 2nd February is still will be there. That fourth order, page 34 says that you were removed from service by the order dated 2/2/2015. It would have been prudent on your part to have looked around for this order prior to filing of the petition. Yes. What do you want
Lordship, an opportunity to amend the petition, Lordship. 2 weeks.
at this stage?
I know it's.
Yes, do you have any objection?
Yes, my lord, I do have an objection because it is a 2017 case. And he was removed from service in 2015. And it was very much inordinate delay. He's a member of the disciplinary organization. He was sent to take a postmortem report to Guwahati. 52 days. He was absent. He was a habitual offender. Appeal was filed. Appeal was dismissed. Well, there is nothing left out for him now. All procedures are already exhausted, my lord.
There is.
And my main contention, your lordship, in the crux of the matter, the main order was not challenged. That is to.
That's why I was.
That is the crux of the point, my lord. That main case was not challenged. The main impugn order was not challenged. Then after this, there is nothing left out.
If we can get an opportunity to amend this, Lordship,
To amend that.
we can demonstrate this is a
To amend
irregular.
To amend the writ petition,
Lordship.
you'll have to file an application.
Application, Lordship, will file application.
He'll be given a chance to make objection.
Lordship.
It's your choice.
Lordship. Otherwise, there is no other way out to, we cannot come. Because it's already 6 years, already 7 years.
Okay, I'm not saying anything on your request.
Some humble submission is before lordship is that the case may be dismissed with a liberty to file a new petition.
No, that's what I was hinting him. I'm not dismissing it. You can withdraw it. With liberty to file afresh.
Because otherwise, it's a 2017 case also, my lord. Quite old.
Liberty.
Because the entire writ petition is not at further procedure. Main impugn order was not challenged. Not
Lordship,
within the-
with the liberty, Lordship, I moved it.
Mr.
SD Purgasto.
S.T. Purgayastan and a council. Praise for withdrawal of this petition. With liberty to file afresh. Para, Mr. White Doloy, Leonard. You're the
Senior counsel for Union of India.
senior CGC.
Yes.
Appears for the respondent. Writ petition is dismissed on withdrawal with liberty as well.
Okay.
Obliged.
Seventeen.
Lordship, in this case, the petitioner was working as a LDA in the office of the Director of Medical Education, Assam, Your Lordship. And wide order dated 11/6.
All respondents are present?
Yes, Lord.
You are appearing for?
Respondent 3, private respondent.
1 minute. Respondent 3 and Ubamanya, you have 4?
For the health department.
1 and 2.
Yes.
Yes. Are you ready?
Yes, Lordship. Otherwise, Lordship, here the petitioner has already been promoted, Lordship. But now the only thing remains that he wants his notional benefit from the year 2020 instead of 2023, because his promotion was given in the year 2023, and the private respondent by now has retired also.
So the limited contention is for the notional benefit.
Okay,
Lordship.
place your case.
So the petitioner was working as a LDA in the office of Director of Medical Education, Assam, Your Lordship. And wide order dated 11/6/2020, the private respondent was promoted. Who was
Where? Page.
Page number 9, Your Lordship, read petition.
Yes.
The private respondent was promoted to the post of UDA, superseding the petitioner, Your Lordship. The petitioner was 14 years senior to the private respondent.
Where's your appointment order?
Appointment gradation list is given, Your Lordship, in page number 10.
Yes.
In that serial number 18, Your Lordship.
Serial number?
18. So he was promoted the post of LDA in 23/3/1996, Your Lordship.
Private respondent's name is here?
No, Your
In the
Lordship.
gradation list? No.
No, he was not serving in the cadre of LDA at that time, Your Lordship.
So you were promoted as LDA
So
or appointed?
appointed as LDA, Your
Fresh
Lordship.
appointment.
Earlier, he was working as a grade 4 employee.
Okay.
So by this gradation list, he was promoted to LDA, Lordship. And after that, wide order dated, Your Lordship, page number 9. So respondent number 3, the private respondent was promoted. And the
Serial number?
in page number 9, Your Lordship, serial number 2, Deepu Gohai, promoted against your post. So it is given here, in the interest of public service and recommendation of selection committee duly constituted by number decision this dated 27/5/2020, the following LDAs, junior assistant of the directorate, are hereby provisionally promoted to the post of UDA senior assistant against the existing vacant post of the directorate in the scale pay of rupees 14,000 to 60,500 and grade pay rupees 8,000 per month. So, so our contention is the petitioner should have been promoted actually. And
When was the respondent number 3 appointed?
the petition after that filed representation.
When was the respondent number 3 appointed?
Respondent number 3 was
As LDA.
Hmm. 27 to 2009. 2007.
Your Lordship, may kindly take up the affidavit in opposition filed by.
See, you're claiming seniority over the private respondent number 3.
Yes, Your Lordship.
You don't know when he was appointed.
It is given in the affidavit in opposition.
What date?
27 to 2007, Your Lordship.
2007. Then?
After their Lordship, the petitioner had
1
filed.
minute. Yes. Then,
So after that, the petitioner had filed three representation, your lordship, and representation are on pages 11, 12, and 13 for considering his promotion, but he did not get any reply, and having no other alternative, the petitioner filed this petition. So in the affidavit in opposition filed by the Director of Health Service, your lordship, so
respondent number?
two, your lordship, this respondent number 2, your lordship.
Yes.
So lordship may kindly take up page number 5. So in that, it is para 10, your lordship, is written. The committee in its meeting held on 29/5/2020.
1 minute. Para 10.
Para 10, your lordship.
Yes.
Towards the last part, your lordship. The committee in its meeting held on 29/5/2020 evaluated the records of the prospective candidates for promotion, and while verifying the ACR's annual confidential reports of the candidates pertaining to the 3 preceding years, it was found that those of Sri Kanakchandra Medi petitioner herein were not satisfactory. In this regard, decision taken by the selection committee is cited as follows. The ACR of Sri Kanakchandra Medi has been verified, found to be not satisfactory, and his sincerity, his relation with public and senior officers need much improvement. Hence, the committee has decided not to consider his name for promotion at this moment, with a scope for consideration in future, provided he improve himself. And also in the next para is written, in view of the above, it is respectfully submitted that out of the 3 vacant UDA position, 2 vacancies have been filled up through promotion with 2 eligible candidates, namely Sri Montu Soikia and Sri Dipu Gohai. That is a private respondent, your lordship. Sri Kanakchandra Medi petitioner herein was not considered for promotion for the reason stated above. It is also relevant to mention herein that the remaining 1 vacancy in the position of UDA in the directorate has been kept vacant, your lordship. So the main reason for not giving the promotion to the petitioner was that his ACR reports were not satisfactory, your lordship. But our contention is that the ACR report was never communicated to the petitioner hearing, lordship, and that is direct violation of the service rules, your lordship, and especially.
You have been promoted now?
We have been promoted now.
Where's the order promoting you?
It is given the additional affidavit filed by the Director of Medical Health, your lordship.
Additional affidavit.
By Director of Medical Health.
Page?
Your lordship may directly go to the annexure and page last
No,
page, your lordship.
additional affidavit. Yes.
In the last page, your lordship, the annexure 2 is given. Therein, the order states that in the interest of public service and recommendation of the selection committee duly constituted by number DME 2016-2008.5237 dated 27/2/23, the Kanakchandra Medi Junior Assistant LDA of this directorate is hereby provisionally promoted to the post of Senior Assistant UDA against the existing vacant position of this directorate in the scale pay of rupees 14,000 to 60,500 and grade pay rupees 8,000 per month. His promotion will be effective from the date of joining of the incumbent into the position of Senior Assistant. So now the relevant part is last part, your lordship, wherein his promotion is effective only after the date of this order, that is 22/3/23. Wherein he ought to have been promoted from the date of the promotion of his junior, your lordship, the respondent number 3.
Where's the promotion of the respondent number 3 to UDA?
And that is given in the Page,
Of the
page 9, the writ petition, Lordship. Order dated 11/6/2020, Your Lordship, Annexure 1. Serial number 2, C. Dipu Gohai. So our contention, Your Lordship, because the procedure was not followed while promoting the private respondent, Your Lordship. So the petitioner is eligible for being promoted from the from 11/6/2020, Your Lordship. Because the ACR comments were never communicated to him, and also the senior, junior, that the rules were also not followed, Your Lordship, and there was no the rules have been violated, Lordship. Our limited now prayer is only that the his benefits that he are entitled to, Your Lordship, could be considered from 11/6/2020, Your Lordship. And in the meantime, the private respondent has retired, Your Lordship.
Yes. You'll have nothing to say then, isn't it? You have retired from service. Only issue is this.
That whether the
What is
ACR
the criteria for promotion from the post of LDA to UDA? Is it on the basis of seniority come merit or merit come seniority?
Seniority come merit, Lordship, it is seniority come merit, Lordship.
Are you sure?
Lordship,
Because that is, if it is seniority come merit,
then he,
petitioner has to be considered.
yes, sir.
And whether the adverse remarks,
Where something-
whether were communicated to the petitioner.
Your Lordship may kindly come to page 4 of the writ.
Of your,
Of the writ.
page 4. Yes.
Speaks about para 8, rule 9 of the Assam Directorate.
Seniority come merit.
Yeah.
Okay. Then whether ACR was communicated to the
Lordship,
petitioner?
to that effect, Lordship, I have received a communication, Lordship, from the Director of Higher Education, Medical Education. It has been stated that he was informed verbally.
Can that be acceptable?
It's not acceptable, Lordship. The rules are clearly.
I'm
clear
not
for-
asking you, you keep quiet.
As per rule, Lordship, they will have to communicate in writing, Lordship, so that
Yes.
they can file a representation. Yes, but this communication I had received, Lordship.
When did you get it?
Lordship, it was received in the month of October 2023, Lordship. But I have received it 3 days back, Lordship, because this was misplaced in my office, Lordship. So from this, Lordship, it can be said that, Lordship, it has been verbally communicated to him, but not in writing. So this may be kept as a part of record, Lordship, because it is the written instruction which I have received, Lordship.
Let us see.
Point number 1, Lordship.
No, it says the outcome of the DPC.
Yes, Lordship, it is not very specific regarding the whether the ACR was.
Whether it was communicated to him, ACR. Here is the outcome of DBC regarding his answers.
And Lordship, which DPC, it is not very.
It says the outcome of the DBC was communicated to him verbally.
then Lordship, in this that regard, Lordship, I can get the specific instruction, Lordship.
In short time only.
In very short time, Lordship. Let it come in the next week, Lordship. So that
Okay, heard, Mr.
J Das, Lord.
J. Das, then is counsel for the petitioner.
But just one point, Lordship, here, outcome of DPC meeting regarding his unsatisfactory ACR.
That I've seen.
That part is also there, Lordship.
Regarding his, the outcome of the DBC regarding his unsatisfactory essay.
it is not very
So only
clear,
one,
Lordship.
because after him being LDA, only one meeting DPC was there in relation to petitioner, that is for the UDA. In that time, he was not considered because his adverse remark. After that, subsequently, he was promoted. So there cannot be any other DPC meeting, your lordship, apart from this one.
The outcome of the DPC
held in
was
2020.
communicated regarding his unsatisfactory ACR. What was the minus of the DPC? DPC said his ACR is not satisfactory and therefore not considered for promotion. That was communicated to you.
But whether the
the unsatisfactory ACR was communicated to you or not, that is the issue that the court wants to know. Why are you trying to come between the court and the respondent?
I'm just trying to read out the part.
I've read it.
Apologies.
Heard so and so for the petitioner, no? You got the name? Mr.
D. Upamanya.
D. Upamanya, and the standing counsel,
Health, medical and health department.
health department.
Yes.
Shall receive instructions as to whether the unsatisfactory ACR of the petitioner was of the petitioner was communicated to the petitioner in writing. Stop. List again on.
Lordship, can it be on 21st, Lordship?
Okay, 21st.
Obliged.